Happy New Year to each and every one of you. Yes, Mr. Sir.
Please, let's say item number 46. I have instruction to withdraw the case, Lordship.
No steps taken. Okay.
Mr.
Mr. H.K. Sharma, Learned Counsel for the petition on instruction submits that the petitioners are not desirous to continue with the matter any further. Also, accordingly, he prays that he be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the writ petition stands dismissed on withdrawal. Interim order passed, if any, shall stand vacated.
May I pray, Lordship? Lordship, with respect to item number 45 of today's list, Lordship, we have withdrawn our Wakalat number from the case. We are intimately raised free, but our name is being shown. Lordship, the petitioner is present here. You would like to apprise your Lordship as a petitioner in person.
When the matter is taken up, we'll consider.
Obliged, Lordship.
And ask him that the IA that has been filed
Lordship.
brings on record very bad
I understand.
material against him.
Lordship.
And if that is true, he'll be in trouble.
Obliged.
Just apprise him of that.
I have told him.
Ask him to be ready with that.
He is there, Lordship. Obliged.
May I plead the Lordship?
And it seems to be his second incident in this connection. Earlier also, there was an incident of forgery.
Since I have withdrawn, Lordship,
No.
I mean,
I'm only requesting as an officer of the court to inform him that.
I have informed you, Lordship. Obliged, Lordship.
May I plead the Lordship? My Lord, I beg to mention item number 54, my Lord. My Lord, in this matter, the petitioner is here. I need some time to obtain instructions, my Lord. 54.
Lord, maybe that fits in the month of February first.
What was the issue here?
My Lord, issue is that the petitioners are 3F appointed dental surgeons. So, my Lord, they have been, some of them have been terminated because earlier also they approached this honorable court praying for regularization that has been rejected by this honorable court. In the meantime, a new recruitment process has been initiated. So, in the petition, their prayer was to pay the arrear salary because after they have been paid salary till their last extension order. After that, although they have continued in their service, but they have not been paid salary. That is one issue. And second issue is conclusion of the recruitment process, my Lord. The recruitment process is under process, my Lord. Regular.
So you want the process to be taken to its logical conclusion.
That is all on the press.
One,
ADR
and
salary.
the payment of whatever amount is there for
Yes.
the period you work.
Yes, my Lord.
You pass that order, you make a verification, do it. And
My
we'll
Lord-
not pass a direction
My
to
Lord-
you to complete the process within a period. You do it.
That period was already given. In spite of that, we have to again approach the sound course for the second time.
Fine. What happened? That's by APSC or by the medical board?
By medical board.
Medical board.
Medical board-
Advertisements issued.
Advertisement.
Election, interview held.
No,
No,
that has not been held.
Why?
Actually, my Lord, because my Lord, the DME, Director of Medical Education, is a ex officio member of the committee. Now DME has been appointed as the Vice Chancellor of the Srimanta Shankardev University. So in charge DME is there, my Lord. So that's why they have written to the government, my Lord, whether the in charge DME can be
Okay.
concluded in the committee or not.
Mr. Bora Learned, Standing Counsel, Health Department, submits that he be granted a week's time to complete his instructions in the matter. Also, Mr. M. Dr. Learned Counsel for the petitioner expresses urgency in the matter. Accordingly, the registry to list this matter again on
My Lord, in the first week of February, my Lord.
2/2/2025.
Yes, my Lord. Yes, my Lord.
Mr. Bora, on the next date of listing, shall apprise this court as to the time limit that would now be required for completion of the recruitment exercise.
Yes,
And in question, recruitment exercise involved in the present writ petition. I think that'll do it.
Yes, my Lord. Obliged, my Lord.
Diplobliged.
May please.
Yes.
The appearance regarding item number 47, Lordship. The matter has become infructuous, Lordship.
Mr. M.K. Bora, Learned Counsel for the petitioner, on instruction submits that during the pendency of the present proceedings, the issue involved has become infructuous. So accordingly, he prays that the matter be closed as having become infructuous. So prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the writ petition stands dismissed on having become infructuous. Interim orders passed earlier stands vacated.
Obliged, Lordship. May I please, Your Lordship? I beg to mention item number 3, 4, and 5, Your Lordship. With the consent of the other side, in this matter, Your Lordship, we filed an IA for implement of new parties, Your Lordship. That's IA was not yet listed. Matter will be listed.
IA
in the
number?
IA was serial number 16049. Your
Who is appearing for the liquidator?
I'm saying.
What will happen to these proceedings, departmental proceedings that were initiated against them? But inquiry report submitted and then there is a stay from this court. Now, what will happen to those?
It is with regard to item number 3, my lord. Most probably they are not pressing on that part. So
Yes.
they are pressing on item number 5.
No. That proceedings are all in midway. What will happen now if we vacate that stay order? What will, because the organization is not there.
Organization is not there.
Is the liquidator empowered to pass orders in that connection? Then they are entitled to all the benefits. Why are you not releasing them?
The liquidator part that has been released, my lord.
Then who else part is by whom?
Only gratuity part that is not with the liquidator.
It is with whom?
It is with Canara Bank, that is lying with the Canara Bank.
Why?
Canara Bank Park Street branch.
How? Karnataka Bank?
There's my lord, 3 banks were empaneled and the gratuity amount is lying with Canara.
No. How can
So
they?
they have-
That
they have
gratuity
filed
amount
it-
is an amount which is with the authority.
That is not
You are
part
the
of
authority now.
liquidator, my lord.
Huh?
That is not a part of the liquidator.
Why?
Gratuity amount.
Why?
As per my instruction, my lord, gratuity amount.
You have
that-
filed an IA.
Yes, Your Lordship.
These
For
are
including
2009
Canara Bank.
matters.
Yes, sir.
We are taking it up on Friday.
Yes.
As prayed for by the learned counsel for the petitioner. The learned counsel for the petitioner, Mr.
A. Hussain, Your Lordship.
A. Hussain, submits that an interlocutory application has been filed in WPC number
7332, Your Lordship.
7332/2015 for impleading necessary parties as respondents in the proceeding. Also, he submits that the matter be taken up along with the said interlocutory application. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again on 9/1/2026 along with the interlocutory application stated to have been filed in WPC number 7332/2015. Powered up as could be 325.
May I please? Your
All right,
Lordship?
Steve.
Back to mention item number 43, Lordship. Subject to Lordship convenient, Lordship, this matter may be taken at 2, Lordship.
Okay,
Highly available.
2021.
May I please, Your Lordship? With the concern of the other side, I beg to mention item number 11, Lordship. In this matter, we need to file a substitution petition, Lordship. Kindly 2 weeks' time may be granted, Lordship.
No,
Lordship,
next, rejected.
the petitioner has died, Lordship.
I know, you were given opportunity, you were not filed. That was sometime in 2020.
Lordship,
2020, you have not filed. We are dismissing it for, it has become abated. We are not giving you any more for the time. When the matter is called up, come.
only 2 weeks' time, Lordship.
No, you have been given enough time. Show me the reason why it was not filed. When it comes, we'll see. Yes, you can't have it every day as per your own convenience.
Yes.
Matters are getting adjourned daily on that count. You were taking time. You then filed something. Sorry.
At that time.
Yes,
My lord, I beg to mention item number 34, my lord. Matter may adjourn, my lord.
30?
4, my lord.
Hmm.
Let Angus, due to some personal difficulties of the Angus councilman, K. Kolita, my lord. His uncle expired, my lord, few days back, my lord.
On the prayer is made on behalf of Mr. K. Kolita for an adjournment in the matter on the ground that he is presently in bereavement. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again on 19.
My lord, in the month of February, my lord, first week of February, my lord.
19. When did his uncle die?
Exactly, I am not remember, but within the Bihu, my lord, might be. Sorry, my lord, within the summer winter vacation.
On 28 1/2025. 26.
May I please, Your Lordship? Lordship, I beg to mention item number 20, Lordship, of the daily list, Lordship. With the consent of the other side, Lordship, matter may be adjourned for the day, Lordship. As because Mr. M.R. Sudhuri, he has undergone surgery, Lordship.
Huh?
Whole bladder surgery, Lordship.
What?
Mr. M.R. Sudhuri, he has undergone surgery, Lordship.
Mr. Emmett Ahmed is there?
Lordship, but brief is not with us, Lordship. Can it be last week of
It is
April?
that case wherein the Assamese medium was provincialized, the Boro medium was not provincialized.
Maybe, Lordship, I have no.
Why keep these matters pending? 2017 Act has come. You will get your thing under that. Okay. On the prayer of the Learned Council a prayer is made on behalf of Mr. M.R. Chaudhary, Learned Council for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the Learned Council for the respondents. Registry to list this matter again on कुछ तरीके पड़ी 27.
May I please, Your Lordship? I would like to beg item number 29.
20?
9. We are for the petitioner. Lordship, my senior is out of station. So kindly list a matter after a week. And this matter has already gone for mediation.
It has come back.
Yeah. But we haven't received.
Leave salary, 300 days. You be here. When the matter is taken up, you be here. If it is to be dismissed, I'll not dismiss it. That much guarantee only. But if I want to allow it, I can allow it. Okay. Mr. Nath.
Lordship.
One clarification. Amongst the set of two, the petitioners are working or the respondents are working?
Right,
They are
they
working.
are working.
We are interfering with that. We have already, but only thing I had a doubt whether they are working or not.
They are working.
I'll just modify that. We are allowed the writ petition. The appointment, consequential, the termination 16/2/2015 set aside, and the consequential appointment order set aside. Now only one line I'll add that you will pass consequential orders appointing them subject to the appeal.
They are orders that will get revived.
No, that will get revived. So they will they will join.
Lordship.
They will join.
Ma'am.
Okay. I think that is what I.
And Lordship is giving some time frame. No?
Accordingly, petition number 1 here be permitted to work as Anganwadi helper in Dakhin Pithial Anganwadi Center, and petitioner number 2 be permitted to continue as Anganwadi worker in so and so, so and so. I thought that they are not continuing, so I'll just modify that. We'll put a time frame, don't worry.
Lordship. Highly obliged. Lordship.
This case, Your Lordship, my part was over. Your Lordship has heard me.
Yes, Mr. Bhattakur.
Lordship, in this case, my part was over. Your
The
Lordship.
only problem is that this file comes back to me again.
Lords. No,
New
Your
things
Lordship,
come
part-
out.
It's part heard. Your
New things come out.
Lordship.
Now, one thing, how can this case be maintainable before the High Court?
Lordship.
I have to go before the Central Administrative Tribunal.
Lordship, that,
Directorate of Census Operations.
Lordship, that is there. Your
Then,
Lordship.
after the decision of
Chandra Kumar.
Chandra Kumar, how can we take up? We can't take up. That day, maybe I missed out.
Lordship
Assam.
has done.
By the word Assam, maybe I
Lord.
just did not apply my mind. But yesterday, when I went through, I said, this is the point. So, Bhattakur, this will not be maintainable. You'll have to go before December. Otherwise, you have
Lordship.
made out a case.
Lordship.
The only thing is
Since Your Lordship. they have
19.1
already-
whether a hearing is required.
Lordship.
That much only. But I don't think so. We should
Lordship,
exercise
the
our.
problem is, Your Lordship, now if it this stays, Your Lordship, I was relegated to tribunal, Your Lordship. Limitations, etc. everything.
Limitation is there. That is, there is a power for condonation
That
also.
is there, Your
And
Lordship.
you have been, this was, you have bona fidely pursuing the proceeding here.
Lords.
Then?
Lords.
I think we will not.
Can it be taken up on Wednesday, Your Lordship?
On the prayer of Mr. S. Bhattakur, Learned Council for the petitioner, registry to list this matter again on Wednesday.
This man.
Ah,
Yes.
Lordship.
maybe on
That-
7th, again I'll change my view. I don't know.
The only thing, Your Lordship, they have also not raised this issue.
Yes, my lord.
But that is a issue which is glaring on the face.
Yes,
That day I thought that he is a state government employee.
yes, my lord.
I did not go. I went into the issue only, did not go into the fact. Okay, fine.
My lord, my name was,
Mr. S.K. Medhi, Lanet CGC,
always, my lord.
for all respondents,
Yes.
is
Present.
present.
Happy New Year, my lord.
Happy New Year.
Yes.
Deeply obliged. Your Lord.
List this matter before any other bench without me. Already there is an order.
Happy New Year.
None appears for the petition on call. The earlier set of councils had withdrawn from the present proceedings and accordingly notices were issued to the petitioner. Requiring him to apprise this court as to who would appear for him in the matter. Also, the notices were issued on however, there is no representation on behalf of the petitioner when the matter was called up. Accordingly, the writ petition stands dismissed for non-prosecution. Learned. You are appearing for?
I am for the elementary education.
Elementary Education Department is
PN.
standing counsel. Elementary Education Department is present.
Made pleasure, lordship.
Who is appearing for the respondents?
This is a covered case, your lordship.
Yes, madam.
Lordship, we have not received any updated instruction
You
after
need not
the,
pay. There is no requirement of any
after
instruction.
the, yes, Lordship.
Because the matter is already settled.
writ appeal was, that
So we are disposing it off.
Lordship.
What is that?
This writ appeal order that.
Oh, that the registry has already put it on.
Hmm.
Anything more? Nothing more.
Lordship.
But Mr.
MH Loskar.
MH,
If they are entitled, they will be Lordship.
what entitled? They are entitled.
Lordship.
MH Loscott, learned counsel for the petition. Also heard Miss M. Bachaji, learned additional senior government advocate, appearing for all.
Lordship, just check, let me check. Personnel Department, Public Agreements. Other than two, Lordship, 1, 3, and 4, I am appearing. Who
Appearing
filed
for
in?
the respondents number 1. Three. And 4. For finance, anybody?
Lordship, someone, but
Also, the petitioners, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities for authorizing to them the areas of their pay and also the pension and pensionary benefits in terms of the accepted recommendations of the Assam Pay Commission of the fifth Assam Pay Commission, fifth or sixth? Sixth Assam Pay Commission. Also, the petitioners herein were working as principal, associate professor of various provincialized colleges in the state. Also, the petitioners retired from their services on attaining the age of superannuation between the period with effect from 1/1/2006 to 31/3/2009. Also, the government of Assam, on receipt of the report of the Sixth Assam Pay Commission as constituted by it in the matter, comma, proceeded to accept the said report with modifications as made by it. Also, accordingly, the Assam revision of pay rules came to be issued. Also, the respondents state, while proceeding to implement the accepted recommendations of the Sixth Pay Commission, comma, had stipulated that the said revision would be effective with effect from 1/1/2006. However, in respect of employees who retired between the period with effect from 1/1/2006 to 31/3/2009, no arrears shall be paid to them. However, employees retiring from their services with effect from 1/4/2009 to 31/1/2010, comma, the arrears working out would be credited in their bank account in one installment. Full stop. The persons involved having all retired after 1/1/2006, comma, the decision as arrived at by the government with regard to release of arrears and a homogeneous class of retired employees having been now differentiated basing on the date of their retirement, comma, led the association representing the retired officers, comma, teachers and employees to approach this court by way of instituting a writ petition being WPC number 61/2011. The coordinate bench of this court, upon considering the issues arising in the matter, was pleased White
Page 32.
White judgment and order dated 28/4/2016 to allow the said writ petition by drawing the following conclusions. Page 41, para 22, A to A. Also, although the state respondents had preferred an appeal against the said judgment and order dated so-and-so 28/4/2016, the same came to be withdrawn with a liberty to prefer a review application in the matter before the review application. Also, the review application having been filed, comma, the same on consideration came to be dismissed. Full stop. Thereafter, the state respondents instituted writ appeal number 4418/2023 before the division bench of this court, assailing the judgment dated 28/4/2016 passed by the coordinate bench in WPC number 61/2011, along with the order passed in the connected review petition. Subpara. The division bench of this court, upon considering the issues arising in the matter, was pleased by order dated 21/8/2025 to dismiss the writ appeal by holding that the object and purpose of a revision of pay is due to increase in cost of living, and when all the pensioners formed a single class, comma, there cannot be any separate classification amongst this homogeneous group, and therefore the actions of the authorities were, and accordingly the decision of the learned single judge was upheld. Also, with the dismissal of the writ appeal being writ appeal number 418/2023, comma, the directions passed by the coordinate bench of this court, White judgment and order dated 28/4/2016, gets affirmed. Also, the petitioners who were retirees post 1/1/2006. Now, the cases of the petitioners who are retirees post 1/1/2006 is squarely covered by the judgment and order dated 28/4/2016 passed by the coordinate bench of this court in WPC number 61/2011. Full stop. In view of the said determination made by this court, the petitioners are entitled to the arrears of pay and allowances as the pension also was not released, no? Arrears of pension
Arrears of pension,
not given.
not given.
Arrears of pay, including the arrears of pension and pensionary benefits upon fixation of their pay in the revised scale of pay coming into effect in terms of the revision of pay rules dash quoted. Yeah. Also, the respondent authorities shall now fix the pay of the petitioners in the revised scale of pay with effect from 1/1/2006 and thereafter release to the petitioners the arrears of pay so working out till the date of their respective superannuation from service. Also, the pay of the petitioners having been so fixed, the pension and pensionary benefits, if not determined, basing on the revised scale of pay applicable, the respondent authorities shall fix fix the pay, pension and pension, fix the pension of the petitioners in the by reckoning the revised scale of pay and release and also release to the petitioners the areas working thereof. The said exercise shall be initiated and concluded by the respondent authorities within a period of respondent authorities Now you have not made the education department a party here.
Yeah. Department is not made party, Lordship.
By the respondent authorities, including the authorities in the education, higher department within a period of 6 months from the date of receipt of a certified copy of this order. Also, the petitioner shall furnish a certified copy of this order to the respondents arrayed in the present writ petition as well as to the Commissioner and Secretary, Government of Assam,
Higher
Education, Higher Department.
I'm deputy obliged.
Yes,
Lordship, as per last order, respondents were supposed to.
what is your grievance?
Lordship, the petitioners are claiming the closure benefits, Lordship.
Okay. You are not the regular employee, you are a casual fixed pay basis employee, right? Now show me that the casual and fixed pay basis employees are also covered under that scheme of VRS. It's basically VRS.
Lordship.
Where is that scheme? Which also says that the casual employees, the fixed pay employees, seasonal workers would also be covered under that scheme. That is what irregular employees.
Lordship, that part was considered in the earlier writ petition, Lordship.
No, that part was not gone into. It just said employees and workers. Whether the workers are also eligible to the closure benefits, where do I find them?
Lordship, in the case, Lordship, this matter may be kindly passed over for the time being, Lordship.
Timing,
but-
okay. If you satisfy me on that, then we will get hold of Mr. Bodwich.
Wait, please, your lordship. Kindly matter may be passed over for time being, lordship. May I please, lordship?
This order was passed on 34/25.
Yes, your lordship.
Why? This was not filed?
Lordship, at that time, the family members were on bereavement, lordship. That's why, lordship.
When did he die?
Lordship, the date I have not.
Then, on 34, naturally he had died.
Yes, yes. On that date,
He had died.
Yes, lordship.
Then we are now how much?
Yes, lordship. The
Let them be in bereavement. We are dismissing it for having
the
been
last
abetted.
chance, maybe. A final chance, maybe, lordship.
Why? How can I? Why should I? If you could not file it for 8 months, why keep this matter pending? We are not interested to have those people. If they come, we will consider. We are not here to go and invite them to come here and contest the case.
Only a last chance.
On the prayer of the Learned Council for the petitioner, as a last chance, registry to our last, the Learned Council for the petitioner submits that he be given a further week's time to file a substitution application in the matter. He prays that no further adjournment shall be taken in the matter again for the purpose of filing a substitution application. Accordingly, registry to list this matter again on 19/1/2026. In the event the substitution application is not filed on or before the next date of listing, the matter would be dismissed as having become abated on the next day.
I'm highly obliged, lordship. Deeply obliged, lordship.
Please.
My lord.
What is left here to be decided?
My lord, only my lord thing is that my lord, as per my lord.
100 posts were advertised. Those 100 posts got filled up in 2004, 2004.
2004.
You people are of the next two dates of appointment. These
Out of the same
appointments,
selection process.
maybe, but these two appointments occasioned subsequently that by that time it had kicked in, and further a coordinate bench of this court has already decided the issue.
Not already decided the issue and law laid down by the Honorable Supreme Court in the case of P.
Have you gone up on appeal? Has that order been appealed against?
Which one, my
That
lord?
6 of 2011 and 6700/2010. This is the one. So after this decision, what is there for me to consider? I'll have to only follow that and dismiss the writ petition.
Which decision, my lord? May
The decision which you have relied upon in the writ petitions which you say is similar
yes.
in your writ petition. You have not worked up on that. What has happened? You should have looked up. Just go through it. We'll take it up after some time. We are dismissing it.
My lord, on the some other day, my lord.
No. Today.
Because my lord, there
Today.
is a very clear
Today.
judgment passed by the Honorable Supreme Court.
We don't know.
My lord.
There are reasonings given.
It says
Same
appeal,
selection.
22, my lord.
So, same selection, same thing. I can't go beyond my.
And in fact, my lord, division bench judgment also, my lord, here in the case of Sanjay Kumar, lordship.
The issue has been Sanjay Kumar. All other decisions have been taken note of. Thereafter, this decision was. You go through it. We'll take it up after some time. We'll take it up at 12 o'clock. 12 bajan mat.
6 of 11.
Thank you, Lordship.
All this cases, it is covered by the what case, my lord?
Covered case.
Lordship is aware that if the court determines certain.
I am not aware of anything until and unless you don't make me aware.
If the court
It
determines
is like
certain issues
Hanuman now.
for certain. facts of
Hanuman
fact.
has powers, but he has to be reminded of his powers.
That's
That is the condition of this court. So you remind me.
If the court determines certain issues for certain sets of facts, my lord, that the issue is then determined for any other matter on the same issue.
Those are broad propositions of law.
My lord.
Bring it
So
down to your case.
It was already. settled, my lord.
1/11/2020. You have been now given appointment, barring one, Shaha. Others have been given as teachers and tutors. What is the error in that?
My lord, this is totally violation of.
You are excess employees.
I'm not excessive. Then I may be hard. by-
Determination made.
That about, my lord, recently we have received a documents, my lord, through RTI, My lord, there was no mechanism measuring stick to determine whether certain teachers are illegal.
There was very good mechanism at that point of time.
No, my lord, no, my lord. It is an admitted fact, my lord. I
And
mean,
the facts that have been brought out in the affidavit clearly reflects, you have not even, you have made broad statements in your reply, but nothing more than that.
my lord, I may be allowed to file those documents, my lord. There is no mechanism, there admission,
If
my lord.
Mr. Ahmed wants an adjournment, I am readily giving him an adjournment,
No, not adjournment, my lord.
but not for anything else.
I want to produce those documents.
What are the documents?
That documents, my lord, there is no mechanism measuring stick to determine whether teacher is illegal or irregular. That is their admission, my lord. And admission is the best evidence against the maker. I may be allowed to put it.
This is a writ court, not a civil court.
Yes, 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 yes.
So we'll go by the preponderance of probability and the things that are come. And you have accepted your appointments.
Not happily, willingly, my lord.
Oh, happily, willingly is not. Where have you said?
My lord, I have said, my lord, it is a case of inequality bargaining power. My lord. Take it or leave it.
Where have you said in your writ petition that?
Writ petition, my lord, that time it was not appointed, my lord, when it was filed, my lord. This is subsequently, my lord, they introduced the all care formula.
No, you were invited for a screening in 2012 itself.
My lord.
And the determination was made thereafter, proximate thereafter. The cabinet memorandum is dated
It was approved on 7/10/2020, Lordship.
17.
7/10/2020.
So now that you have accepted that, you will have to challenge that, Mr. Ahmed.
Not happily accepted, my lord.
But that we'll have to know.
Before that, my lord, we file a representation, not to include us. Before that, we have filed another application, my lord, whether we are required
So
to
this
file the-
determination by the committee is,
Your Lordship will find the cabinet memorandum at page 160.
we got it. That is different.
My lord, my humble prayer, your lordship, my lord, I am allowed to file those documents, my lord. It will help me, my lord. Because it is a case of inequality bargaining power.
Mr. Ahmed, learned counsel for the petitioner.
With the mighty
Ahmed,
congress,
learned counsel for the petitioner. Prays that he be granted a week's time to file an additional affidavit to bring on records, documents having relevancy to the issue, having documents in support of the contentions raised by the petitioners in the present proceedings. Also, the matter is pending since 2017. However, considering the prayer made by Mr. M.U. Ahmed, learned counsel for the petitioner, petitioners are granted time till 21/201/2026 to file the additional affidavit. Registry to list this matter again on 27/1/2026. It is provided that in the event the additional affidavit is not filed on or before 20/01/2026, no such affidavit would be permissible to be brought on record by the petitioners in the matter. Okay.
I have another prayer, my lord. I'm sorry to trouble your lordship, my lord. When the case was filed, my lord, the district was Sibsagar district, my lord. It has been changed to Sarado district. I may be allowed to correct a mistake.
That is simple. That we will take care of. But
some
you buy the elephant, the rope, we will find it for you. Don't worry.
My lord.
The rope to tie it, we will give it for you.
My lord.
But you buy the elephant first.
Petition number 7, my lord.
Mr. In the additional affidavit, bring out record. I'm on the meat of the matter. These things can be taken care of.
My lord. I may be at full length, my lord.
Full length?
Yes,
full day?
I will be happy, my lord.
We will ensure that even if the writ petition is dismissed, Mr. Ahmed is happy.
My lord. Oblige.
Yes, Mr. Tolda.
My lord.
What is your game? What is your
My lord,
case?
it was physical disability 50%, my lord. 3% reservation for the post of, my lord, ward boy and night chowkidar in the health department, my lord. I applied for, but my case was not considered, my lord. So, my lord, they have filed an affidavit saying that out of 329 posts, 224 posts are
Only
filled up,
filled up.
105 is still pending, my lord. And one post are kept vacant for me, my lord.
Okay.
the
By
in-
this
in-
court.
Yes, my lord, by the interim
Anything
order.
more?
No, my lord, I was supposed to, I wanted to file an even reply, but I could not because I RTI filed, but no reply came
Okay,
regarding
fine.
the
The
similarly situated.
2018, the affidavit was filed. Today, that question is
My lord,
immediate.
RTI could not be, reply could not be
Fine.
obtained.
Yes, madam.
He has not qualified, Lordship, in
That is it. He has not even disputed that.
Yes, Lord.
My lord,
Heard Mr. Ekit.
my lord, one small prayer kindly, my lord.
Ah,
He may be, my lord, I may be allowed to file the representation giving details, my lord, may be
No.
considered within a time.
No.
Another point is
that, if you don't have anything, but their statement in para 11, that you did not qualify in the written examination to be considered in the next stages of this election process.
My lord,
You have not denied that.
my lord, as far as either those who have scored lesser mark than us are given, my lord.
You have not even brought that on
I
record.
could not bring it, my lord.
Well, forget it.
Because
2018.
I filed
Appeal.
the number of time RTI filed, my lord.
I heard Mr. A.K.
They
Talukder,
could have
Learned
produced the
Counsel
documents
for
before
the
your lordship,
petitioner.
my lord.
The grievance raised in the present writ petition is to the effect that the petitioner, who is a person with benchmark disability, although had participated in the selection process in pursuance to an advertisement dated 16/12/2017, his case was not considered for, he was not recommended for appointment against the advertised post of, against the post advertised. Full stop. The petitioner, in pursuance to an advertisement dated 16/12/2017, issued by the Director of Health Services Assam, had submitted his application for appointment against the post of,
What the post, my lord?
for appointment
ward
against the
boy
post of ward
chowkidar.
boy
A night
and night chowkidar as advertised. Full stop. The petitioner had, along with his application, submitted a certificate envisaging a disability certificate issued to him by the competent authority. Full stop. It is to be noted that by they said advertisement, 3% vacancies, 3% of the posts available were reserved for persons with benchmark physical disability. Also, the petitioner,
9 post, my lord, perhaps.
3%.
As page 5 of the opposition, my lord, file number.
Also, the petitioner, the application of the petitioner being found to be conforming to the eligibility criteria set out in the said advertisement, he was allowed to participate in this selection process. The petitioner participated in the written examination also. Thereafter, the result, the select list was published on 17/5/2018, and therein the name of the petitioner not figuring, he had instituted the present writ petition. So the petitioner had prayed, petitioner in the present writ petition had prayed that his case be directed to be considered against a vacancy following within the 3% reserved post for physically disabled persons. Also, Mr. A.K. Talukder, Learned Counsel for the petitioner, has reiterated the by reiterating the facts noticed herein above, has submitted that the petitioner being a disabled candidate, disabled person, is not disputed by the respondent authorities. Also, the petitioner had participated in the selection process and he was entitled to be considered for appointment against the advertised post for which he had submitted his application. Mr. Talukder submits that the respondent authorities, without assigning any reason, had proceeded to deny to the petitioner his due appointment against the post reserved for persons with benchmark disability, while the advertisement in question. Accordingly, in the above premises, Mr. Talukder prays that a direction be issued by this court to the respondent authorities to appoint the petitioner against any one of the posts reserved for persons with
Disability.
Persons with benchmark disability. So, per contra, Ms. Bora, Learned Counsel for the Learned Standing Council Health and Family Welfare Department submits that the petitioner, although had participated in the selection process, he did not qualify in the written examination. Accordingly, the case of the petitioner was not considered for the further stages of the recruitment process. Also, the petitioner not having cleared the written examination, the case of the petitioner cannot be considered for appointment even against the post reserved for persons with disability in the recruitment process in question. She further submits that the 3% reserve posts kept reserved for persons with disability have been filled up by selecting candidates found suitable on merits in the said recruitment process. Also, I've heard the Learned Counsel for the parties and perused the materials available on record. The facts noticed herein above is not in dispute. Also, although the petitioner is a person having benchmark disability, the petitioner is a person having benchmark disability and he having applied for the post of night chowkidar and ward boy in pursuance to the advertisement dated 16/12/2017, the petitioner was permitted to appear in the selection process. Also, the petitioner appeared for the written examination. However, the materials brought on record reveal that the petitioner did not qualify in the written examination so held. Also, the said aspect of the matter was brought on record by the Director of Health Services Assam by way of filing an affidavit on 20/12/2018. The relevant contentions raised in the said affidavit being relevant, the contentions raised in the said affidavit being relevant is extracted herein below. Para 11, para 12, page 24-25. Para 14. The said
There are 15, Lordship.
15. 15. 11 over 15, my dear. So the said contentions made by the respondent authorities in the affidavit in opposition has not been denied, has not been disputed by the petitioner by way of filing an affidavit in reply, although the said affidavit in opposition was filed way back on 20/12/2018. So, the petitioner, Sapara, having not qualified in the written examination, he having not participated in the his case could not have been considered further in the said selection process, and accordingly, the petitioner is not entitled to be appointed against any of the vacant posts advertised vide the advertisement dated 16/12/2017. Further, the petitioner not having qualified in the selection process, his case cannot also be considered as a person having benchmark disability. Also, in view of the said position as emanating in the matter, and the petitioner not having qualified in the selection process, has held in pursuance to the advertisement dated 16/12/2017, this court is of the considered view that no direction can be issued to the respondent authorities to consider the case of the petitioner for appointment against any one of the vacant posts advertised vide the advertisement dated 16/12/2012.
17.
Also, Accordingly, the present writ petition is held to be devoid of any merit and the same stands dismissed. However, there would be no order as to cause. Also, the interim orders passed by this court, while order dated 25/6/2018, stands vacated. Sorry.
Obliged,
Even if you had disputed that, we would have done so.
Hello, the RTI reply could not be obtained. The lesser marks are given. Could
Mr.
not be.
Mr. That qualification that you did not qualify in the selection process, for that you don't require an RTI. You could have filed an affidavit saying that this is wrong, there was no cutoff marks. Enough. We would have then caught them. This is what you have to be very careful.
This witness, my lord, David, my lord.
My lord, with all humility, my lord.
With all humility, you take your seat. With all humility, take your seat. Let Mr. Doctor cross the Boiteroni. Then we will see whether we will have to have you. Yes.
True, my lord. They were, my lord, appointed in, my lord, 1980s, my lord, 90s, my lord. A grade 4 employees, my lord, and they're entitled to promotion under, my lord, the ministerial, my lord, Ministerial District Establishment Service was 1967 on seniority cum merit basis. Now, my lord, no promotion process was at all initiated, my lord. And they were left out. Then they approached this honorable court. This honorable court will pass an order, my lord, saying, my lord, that page 24, my lord, that they should work out, my lord, the year-wise vacancies. Page 24, my lord. That being the position, the sponsor directed to work out the year-wise vacancies, they have to fill the state vacancies by applying the ratio of 90:10, and accordingly, accordance with the provisions of the Assam Ministerial District Service Establishment Service Rules 1997. The post of section assistant will also be included in the grade 3 post, along with law division assistant, junior assistants. Only after the proportion of vacancies is to be filled up, the above ratio is worked out. Respondents may proceed with the same and fill up the manner as indicated above. My lord, thereafter, my lord, what happened? There was an amendment of the rules, my lord, and the qualifications now have become degree, my lord. Earlier it was, my lord.
And that was prior to the passing of the order.
Order passed, my lord. That's true, my lord. Then, my lord, they pass an order, my lord, at page 28, my lord. And where, my lord, page 29 is the order, my lord. After working out the vacancies, page 29, my lord, the last but one paragraph. It starts from whereas I have perused the order, it is so and so. Then in the middle, my lord, about, my lord, 5 lines from the top, my lord. After working out the vacancies, as per the provisions of 1967 rules and complying with the directions of this honorable court, it appears that there are vacancies available as on date, but to change the statutory prescriptions that they occur during the pendency of the 3 petitions. The department is pleased to pass the speaking order in compliance with the directions of this honorable court. The change in the statutory prescription that had taken place during the pendency of the writ petition, this writ petition, was in the form of amendment that had taken place in the Assam Ministerial District Establishment Service Rules 1967 on 15/10/2015. Amendment of the said rules was duly notified in the so-and-so Gazette. As per the old rules, the qualification required for grade 3 was HSLC or equivalent, past and 7 years of continuous service in the district establishment. However, the amendment of the said rules, as stated here and above, the qualification of the post of grade 3 was amended with the following, it was inserted. In so-and-so rule number so-and-so, the high school leaving certificate equivalent.
So 2 of the petitioners were found to have BA, they were considered for promotion.
Minor.
And the rest not having BA, they are not considered. What is the error?
My lord, is that so far the earliest, of course, my lord, the law has, it's that the SP considers.
That has to be on the date of the consideration, the Rajkumar.
But my lord, that's true, my lord. But then what has happened here, my lord, since no promotion process was initiated at all, my lord, they were denied the opportunity, my lord, to be considered.
Too late
That
in
is
the
the
day.
only thing, my lord.
That's too late in the day to say.
Understand that, my lord, but then this is how they were left out, my lord.
That is too late.
Otherwise, my lord, your lordship is right. The law has been, my lord, now will clarify, my lord, that it has to be on the date of, my lord, promotion, my lord. Rangaya's judgment, my lord, and thereafter.
Rangaya gone. Rajkumar has
gone. Ramkumar, my lord. Rangaya's judgment is gone, my lord. But in Ramkumar also, my lord. Ramkumar also, my lord. Rajkumar, sorry, my lord.
Rajkumar,
Rajkumar, my lord. Copy.
2022 SSC online.
Yes, my lord.
SC 680.
My lord, It says, of course, my lord, there is no universal rule, my lord, which, my lord,
Oh,
that is there, my lord. The right to be considered to promotion occurs on date of.
that is there, but the consideration will be on the set of rules holding the field on the date of.
That is there.
And Rangaya was that it will be on the date of the vacancy.
True, my lord.
But that changed.
Contradiction, true, my lord, but contradiction here is, my lord, that so far as these persons were, they are not given an opportunity, my lord, to, my lord, be considered for the part of promotion, my lord.
Can't help it.
Consideration for promotion is a fundamental right.
It will be a futile exercise now, that consideration. Consideration which will not give you any result is a futile exercise. So even if the violation is there, that is of no, that is cannot be a violation as we understand violation to be. You're dismissing it, but I'll get those judgments, I'll incorporate Rajkumar. By second up we will do it. No, there is one more. Raisana Hills is there. Following that. That was it.
Pleasure, lordship.
Registry to list this matter before any other bench without me. That Borkhetri College. Not finished, the matters are still there.
Yes. Serious. Lordship, by last order, the petitioner was.
No, I said not before me.
Lordship, the matter has become infectious because petitioner got the appointment. My lordship, the matter has become infectious.
Both the writ petitions?
Yes.
Huh?
Yes.
Why?
He got the appointment.
Oh, then you wasted our time. What to for that? Huh? You wasted our time from 2018 till now. How many days we have considered this? Huh? Gaumra.
Gaon Pradhan now.
Gaon Pradhan. Okay. That means that last advertisement, that came in your favor.
Yes.
Now we have doubts in that advertisement. No, we are hearing. We have doubts in that process of selection. We want to review that selection. What do you say? Okay. You are also same. Got your appointment.
Yes, sir.
Both the petitions have become infractors. Your name?
J. Hussain.
You are appearing for?
S. Hawk.
Both.
Yes, my lord. On leg in that footnote.
Both the cases you are there, Mr. Hawk.
Yes, sir.
Heard, Mr.
J. Hussain.
J. Hussain, learned also along with Mr. S. Hawk, learned counsel for the petitioners. In the above noted writ petition, also heard Mr. J. Handick, learned standing counsel revenue department, as well as Ms. M. Bachchaji, learned additional senior government advocate, appearing for the state respondents. The learned counsel for the petitioners submit that during the pendency of the present petition, the petitioners in the above noted writ petitions have been on their on their selection, been appointed as Gaon Pradhans. So accordingly, they submit that the present writ petition has become infructuous. Prayer is not objected to by the learned counsel for the respondents. So, in view of the submissions made by the learned counsel for the petitioners, petitioners in the above noted writ petition, the writ petitions being WPC number so and so are stand closed as having become infructuous.
May I please, Lordship? Lordship, the case is, Lordship, as per provisions of Lordship, persons with disabilities, equal opportunity protection rights and full protection act, Lordship. Advertisement.
2005.
Yes, Lordship.
In
the year 2005, Lordship.
How old are you now? 50?
8, Lordship.
8.
2 years remain, Lordship, and 3/4 are vacant, Lordship, at this.
Can't help it. You are beyond the age of appointment. You came up very late. By the time you came here, you were 51.
Yes, Lordship.
You were beyond the age of even the age beyond the relaxed.
They are, but for the anomalies of the government lordship.
You were in the street. You be in the street. You were protesting in the street. You continue that. We have nothing to say. But here, this cannot be entertained.
Some others.
Say something. Come on, counter me. Give me something.
Similarly situated persons lordship.
Oh, that
after
is
their
in
age, lordship.
2015.
No, lordship, after their, after lordship, their age bar lordship, they also got appointment lordship, pursuant to the order of the Honorable High Court.
Now show me, where is your selection for this?
Selection is lordship at page.
That is not the selection. You say that that is the district wise, that is bad. There was a fresh selection made. In that fresh minutes, the list prepared, where is your name? Where is the material to show that? This one, annex page 16.
16 lordship.
This is disputed in the earlier round of writ petition. Page 21 writ petition. This is gone. Then you say that they had, and the coordinate bench also says that there was a fresh thing made. In that fresh thing, where is your name? At what number? What position? Who are the persons below you appointed? Where are those particulars?
This particulars is not.
Then how can I pass an order in F? You satisfy me, I'll catch it. But the matter should come from you. Dismiss.
Lordship, this was not on the part of wrong not on part of me, lordship.
Mr. Counsel, you drafted the writ petition. Where are those pleas taken? You had the benefit of the order of the coordinate bench before you. That although my name is there in the even in the review list, but persons below me, so and so, so and so, so and so have been appointed, but I was not considered. Simple, that much, one line, enough.
Lordship. It was not there, lordship.
So I'm helpless. How can I now go and... It is called roving inquiry, not permissible. And what happened after this? You had come up after this order passed in 2015. What happened?
Lordship, I have stated in para, lordship.
Para?
Lordship. Lordship. 11 lordship, para 11 lordship. The petitioner begs to state that on 23/4/2015, upon hearing the parties of the Honorable Court, considering the fact that 134 of the backlog vacancies out of 662 could not be filled up, was pleased to dispose the writs of the said WPC number so and so, directing the respondent authorities to appoint the said writ petitioner in the available vacancies related.
And these appointments have taken place thereafter, Mr. Counsel. How can you demonstrate that persons below you were appointed? Mr. Bora, wait. What is happening in these cases?
Your Lordship, the thing is, before actually my learned friend has started, but this department as such has been.
Forget it. Forget that change.
That's why-
It is just the same bottle, old wine in a new bottle. That's all. We are ignoring that. Why these people have to be here before this court? And this is not the only proceeding. There are many. And see, they have destroyed their life because of this, waiting in anticipation.
Lordship, if I have to say that, then they were actually fenced, the petitioners in the.
Forget it. We'll come to that.
Petition.
What happened after the decision passed in 2015? What did you do?
Otherwise.
Was appointments made?
That instruction is.
Why from
because
this matter is pending from
now. in
2018?
Yes, I understand, but the department has been bifurcated and. it
Forget
has
the
now become
bifurcation, it's
Department of,
it's the same. In my mouth, it is still the director of
Social Justice and-
social welfare.
Now it has become social. Justice
Women and child, I don't know, they put it down.
There
It
is
doesn't
a
come in
standing
fact.
council, your lordship, Mr. RM Das. In fact,
Okay.
the order in fact reflects of 18/3/24. The Social Justice and Empowerment Department. was
Okay, but
invited
Mr.
to
Bora, you are appearing, you can always take an instruction
Complete it.
from the director, call up the director, tell him after the 2015 order passed by this court, what steps were taken. Just that much.
Lordship may grant me 1 day's time. your
Okay, one day, why 1 day?
A
I'll
day
take it
after
up on
tomorrow.
Wednesday.
Wednesday, your lordship.
On Mr. Bora, D. Bora, Learned Counsel for the petitioner, for the respondent. Learned Government Advocate appearing for the respondents is directed to apprise this court upon receipt of instructions as to the manner in which the selection process was taken forward after the passing of the judgment and order dated 23/4/2015 by a coordinate bench of this court in WPC number 1424/2011 and analogous matters. Registry to list this matter again on Thursday,
Lordship, Wednesday, your lordship.
Wednesday, 7. Just get that instruction. Huh? Because he is here, I don't want to dismiss it on this thing. With some metal, I want to dismiss it so that he also does not get a shock.
Understand. your lordship.
Is your lordship. Lordship, here Miss A. Gayan is appearing, your lordship. She's not well. And affidavit in opposition here is yet to be filed, your lordship.
We are not concerned with the affidavit in opposition. I only want to know how the powers under the CCA rules was invoked. If it is permissible, fine.
Lordship, I'm
We are
not,
dismissing the writ petition.
Lordship, I'm not appearing in this matter.
No, I know that. But you are appearing for Ms. Gayan and what I told you is for her ears.
Yes, sir.
Through you.
Yes, sir, lordship.
When?
Next,
How bad is her condition?
lordship, I have no idea about that also.
She is better. She can come this week, next week, when?
Next week, your lordship.
A prayer is made on behalf of Ms. A. Gayan, Learned CGC, for an adjournment in the matter on the ground that she is indisposed. Prayer is not objected to by the Learned Counsel for the petitioner. Accordingly, registry to list this matter again on Vice Nori. Vice 22 or 1/2026. Ms. Gayan shall complete her instructions by the next date of listing and apprise this court as to the manner in which the powers under the provisions of the Central Civil Service, CCS Dangarobode, brackets, classification, control and normal and appeals, bracket over rules 1985, was permissible to be invoked by the Commandant 31 Assam Rifles for the purpose of terminating, for the purpose of dismissing the petitioner from his service in pursuance to his conviction by the criminal court. And Mr. Counsel, where are the acts? Where are the rules? You can't just come and walk
Yes,
into a court and just make some.
Next I will bring.
Better. The rules would be of 2008. Your termination is 9. Don't get the new rules.
May I please, your lordship? Lordship, kindly matter may be adjourned for a day. My senior has some personal difficulty. He's not in court today.
Huh?
My senior has some personal difficulty. He's not in
Why?
court today.
What personal difficulty? He's in court.
No, he's not in court today. Kindly matter may be adjourned for a day, lordship.
Who is your senior?
NK Kolita.
Huh?
NK Kolita.
Yeah, make NK Kolita is present. You call him, we'll take it up after some time if required.
He is not present today.
He is not present today. Tomorrow. Wednesday, Budvar. On the prayer of the Learned Council for the petitioner, registry to list this matter again on Budvar. 7. Huh? No further adjournment will be given, madam. 7. 5 sleep for Hariba.
My lord, in this case.
Ready for final hearing?
Yes, Lord. No, my lord,
Why?
reply has not been filed.
Oh, did this court prevent you from filing reply?
I don't have communication, my lord. with
In which case you want to file reply?
Both cases, my lord.
Both cases. When was the affidavit filed?
My lord, I don't have communication with my client, my lord.
Ah,
I have no communication with my client.
then you forget it. Why are you making unnecessary submissions just to get the matter adjourned?
Please, my lord, 2 weeks time.
No, not even a day's time. Yes.
My lord, I will
How
file-
many people are involved here? Forget petitioners, respondents.
Total 4.
4. What are the names?
They are
Kiran Saklari?
Yes, Lordship. Kiran
Hmm.
Saklari, Baburam Boro, they are the petitioners. Then Meena Bormon and
Kiran Kaklari next.
Baburam Boro, Baburam Bosumotari.
Baburam. Bosumatari. Then
Meena Bormon,
Meena Mormon is also a petitioner.
petitioner, yes. Lordship. And Vishwanath Bari, he is also a petitioner.
Wari.
Yes.
And the respondents? These are the petitioners and respondents.
Yes.
And Kiran Kaklari is in the petitioner in?
In WBC number 5688.
568819. And respondent in?
Respondent in
Respondent number?
respondent number 6 and 7 in the other cases.
So how can Kaklari be 6 and 7 both?
No, 6 is 7. Saklari is 6.
Ah.
In 7686/17.
7686 of 17.
Yes.
Okay. Baburam Bosumatari petitioner?
In the second case.
Number?
Number 2 in 5688.
Petition number 2 in 5688.
Yes.
19. And respondent in?
No, he is not the respondent. in this
He is
case.
not respondent in
Yes.
it. Meena Burman?
In WPC number 7471, he is respondent number 7.
That is what I'm asking you.
Yes, Lordship.
7471.
71.
He is not there in 7686.
No.
7471 2017.
Yes.
Meena Burman?
Meena Bormon, petitioner in 7686 and respondent number 8 in 5688.
Vishwanath Wari?
Petitioner is respondent number 7 in 5688 and petitioner in WPC number 7471.
Okay. Now, all these 4 have come through that selection at the same advertisement, same selection.
Same environment, same selection.
No dispute on that.
No dispute on that.
All appointed as LDA.
Yes. Fixed day.
That's it. Now, where do I get the marks of each and every candidate? So that is the determining factor?
Yes, Lordship. That is no. Lordship may come to page 29 of my petition. To that.
5688.
Yes.
29.
Determination of inter-se seniority and regulation of the services to the vacant post with SIU. Here, Lordship may find, I read the whole, otherwise it will be difficult to understand. With reference to the subject cited above, it is observed that the directors, CHCs of the departments and other appointing authorities have submitted proposal for regularization of service of the incumbents who were appointed on fixed pay basis with or without going through the selection process conducted by Central Selection Board, CSB. The following process may be adopted. Also, there is two types of appointment.
You
One
go
by
ahead.
CSB, yes.
Go ahead.
The following process may be adopted for the regulation of the fixed pay employees to the departments in the following manner. The inter-se seniority of the fixed pay employees may be determined in respect of appointment given to incumbents without selection process of CSB. That we shall not come under that. Number two, in respect of regularization of fixed pay employees who were appointed after going through the selection process of CSB, the inter-se seniority may be determined on the basis of merit list prepared by the CSB amongst the candidates, fixed pay employees recommended by the department.
Now, where is the marks obtained by the
So that
candidates?
marks
By-
is not available, but the selection in the CSB, the merit list is available.
Where is that?
That is page 32. It starts from page 32.
32? Okay. Where is the petitioners?
Petitioner is a serial number 15 and 17.
15, Aklari,
Yes.
WPC 5688. 19. And Baburam?
Baburam at 17. In between them, Hina Bormon at 16.
Okay. Now, Meena Bormon is petitioner in 768019. And where do I get this Bishwanath
He
Wari?
is at serial number 25. This is the position, but without following this, the private respondents were made senior to us in the earlier cases. Then we filed a repetition. That repetition was
Your
allowed.
writ petition was disposed of, directing them to fix the seniority in terms of 5.
Yes, Lordship.
This is the direction?
This is the direction. But what happened thereafter?
Oh,
The authority,
Thereafter, we'll see.
the
Yes.
authority prepared a
Joining.
no
Date of joining.
date of joining, Lordship. That was illegal because all fraud in my.
No, Mr. Sharma, I got it. Why
Yes,
why
yes.
waste your energy? Sit down. Yes, Mr.
My lord,
Come on.
kindly see page 22.
22
Yes, my lord.
of
7171, my lord.
717.
Bishwanath Wari, petition.
Page 22.
Page 22.
Hmm. Hmm.
PM DICC Sirang,
Hmm.
serial number, my lord, 1.
Hmm.
Grade 3. Grade 3 junior assistant, Sri Bishwanath Wari. Date of joining 28 to.
Oh, forget it. How can you beat on date of joining? It will be basis on the marks. Have you disputed that marks? You have not disputed that marks.
So, my lord, I have to file this reply.
Oh, no, you can't. You're not permitted. You had enough time from 2017.
My lord, since there is no communication with my client, my lord, that is the reason, my lord, for.
Your writ petition is there. Your writ petition is there.
Yes, my lord.
And
But-
in the writ petition, you have also annexed the order of the
Yes.
writ petition filed by him. Now you come to your writ petition. 7171.
Yes.
Come to page 41, para 17.
Yes, ma'am.
Para 17. In terms of 5/9/2011. So we can understand only this. And 5/9/2011 says that persons who have been recruited through a selection process by CSB, their merit will be the determining factor for assigning seniority. What more is required? Why keep this matter pending?
My lord,
Finish.
just
End
one
of
week.
the matter.
1 week, my lord.
Not even a day. I can give you time till 2 o'clock if you want to make your submissions. Please don't give up this habit of just adjourning matters.
No, my lord. I am
We
not-
come prepared. We read and we'll not let it go futile. Sorry.
On Friday, my lord.
No, today, 2 o'clock, 2000. I can't read this 4 briefs again. Sorry. Today. Just show me that a criteria other than 5/9/2011 is applicable. Enough. I'll throw off Mr. Sharma's petition. Yes. 24 to 26, 2000.
May I please, lordship. Transfer order of 2019, lordship.
Gone.
Lordship.
What is there now? 19,
Yes, lordship.
6, 7 years.
No, stay order was there, lordship.
Okay, fine. We are vacating that stay order, directing them to pass fresh orders.
Lordship. Lordship, I am challenging on 2 counts, lordship. First is one office memorandum is there.
That 3 years that
3
you
years,
should have.
no.
That is gone now 3 years, now 8 years. We'll ask them to send you to Sodia or Dhubri.
Lordship, within a period 1 year only I have transferred.
And tell me one thing. You were appointed in Nagaon.
Yes, lordship.
How were you brought to Guwahati?
It's a true
Why?
attachment, lordship.
Why? Where is that law with regard to attachment? From Nagaon to Guwahati, you were attached, you have no problem. Guwahati town, main to Jalukbari, you have problem.
Yes, lordship.
Why? Dismissing this.
Lordship, then, lordship.
We are reviving that order.
Lordship. Then, lordship, there is another issue, lordship, at page number 22. This was sought to be done in an undue haste manner, lordship.
Oh, forget the undue haste.
Lordship, at page number 22, lordship.
You have Bhavesh Kolita.
Note 1, lordship. Note, by Principal Balbhavan, that's the last one. As he is under the direct control of you and stated you have already released him from the establishment. So his prayer
That is a administrative thing there.
it was done in within a
Nothing
period
is
of
there. But
24
see, you're bringing from there to here, Nagaon to Guwahati.
That is after 1 year, lordship.
Be that as it may. Be that as it may. 3 years is the time.
3 years, Thursday.
Why before 3 years you were brought here? And how was it done?
In attachment, lordship.
I know. Why?
Thereafter,
Why attachment?
That is
What is so great about you that without you, the services here will not be done? That the office will be closed down?
Lordship, I am not doing anything for that purpose, lordship.
This attachment is not on your basis.
Not, lordship.
On your request.
Not, lordship.
Sure.
Sure, lordship.
Okay. Careful. Sure.
Lordship.
Okay.
And this is the 2 counts, lordship. That office memorandum within a period of 1 year, and this is undue haste manner. So, lordship, I will submit a case, lordship.
Nothing. What is the position today? Where are you?
I am still at Balbhavan, lordship.
Balbhavan here.
Yes, lordship. Paragraph 17, lordship.
Oh, Jiten Bora, this much water has flowed down there. Yes.
We have not filed any affidavit, lordship,
We
but
not-
as per our instruction, lordship, that order, that memorandum that he is challenging, lordship, this is not in their lordship. And for any public interest in case of administrative exigency, lordship, that to be no requirement of, he is telling that the approval of the chief minister and all these things, lordship. This is in respect of grade 3 or grade gazetted officers only, lordship. So they are in this- yes, lordship. It is for the gazetted officers only. And within the district, actually, lordship, no approval is required.
Why did you bring him from Nagaon to here?
Lordship, that point I don't have, lordship. That one,
He's very powerful.
lordship.
Where is the impugned order?
Imperial page number 17, lordship.
And the respondent number 5 has not come up.
Not come.
Okay, heard Mr. M.K. Bora, Learned Counsel for the petitioner. Also heard Ms. M. Bachaji, Learned Counsel, Learned Additional Senior Government Advocate appearing for the respondents number 1 to 4. None has entered appearance on behalf of respondent number 5. The challenge in the present proceedings is to an order of transfer dated 26/8/2019 issued by the Director of Social Welfare Assam, Guwahati, by the then Director Social Welfare Assam, transferring the petitioner from the Office of the Principal, State Bal Bhavan, Bal Bhavan, Guwahati, to the Office of the Establishment of the Superintendent, State Home for Women, Jalukbari, in place of the respondent. Why is the respondent number 5 herein? The petitioner was initially appointed as a grade 4 employee in the establishment of the program officer, divisional ICDS cell, Nagaon, wide and order dated 28/10/2015. Also, thereafter, wide and order dated 9/7/2016, the then Director Social Welfare Assam proceeded to attach the services of the petitioner to the Directorate of Social Welfare Assam with immediate effect. Also, subsequently, wide and order dated 10/8/2016, the petitioner was transferred from the establishment of the Divisional Program Officer, Nagaon, to the Office of the Principal, State Bal Bhavan, Guwahati. The petitioner accordingly joined his transferred place of posting and was continuing therein. Also, thus, the petitioner was issued with an order dated 26/8/2019, transferring him from the Office of the Principal, State Bal Bhavan, Guwahati, to that of the Superintendent, State Home for Women, Jalukbari, vice the respondent number 5. Also, being aggrieved, the petitioner has instituted the present proceedings. I've heard the Learned Counsel for the parties and also perused the materials available on record. The contention of the petitioner, the Learned Counsel for the petitioner, is that the order dated impugn order dated 26/8/2019 was so passed within a period of 1 year from the date the petitioner was transferred to the Office of the Principal, State Bal Bhavan, Guwahati, and accordingly, the same was not sustainable. Also, this court, wide order dated 2/9/2019, while issuing notice in the matter, was pleased to stay the effect and operation of the order dated 26/8/2019. Also, the office note, the office notes reveal that the notice was service of notice upon office notes reveal that service of notice upon the respondent number 5 was completed. However, he has not appeared in the present proceedings. Further, the order dated 26/8/2019 being stayed, the respondent number 5 has also not raised any grievance with regard to the interim directions passed in the present proceedings. Also, in view of the above, without entering into the merits of the matter, considering the long lapse of time occasioning since the issuance of the order dated 26/8/2019 and during the interregnum period, the petitioner continuing in the Office of the Principal, State Bal Bhavan, Guwahati, this court interferes with the order dated 26/8/2019. Also, having interfered with the order dated 26/8/2019, this court provides that it is open to the respondent authorities to consider the case of the petitioner for transfer in the event exigencies of service so demand and or there exists administrative exigency for the purpose. Also, accordingly, the petitioner, if found required to be transferred from the present place of posting, His case be considered strictly in accordance with the policy in place in this connection and appropriate orders be passed by the concerned authority in this connection. Also, till such orders are passed, the petitioner shall continue against the post of as a grade 4 employee in the establishment of the principal Bal Bhavan body, state Bal Bhavan body. With the above observations and actions, present writ petition stands disposed of.
Obliged, Lordship.
Enough?
Obliged.
No up?
Obliged, Lordship.
May it please your lordship. Lordship, I think this matter become influx first.
Lordship, I have taken instruction from my client just minutes back. He hasn't received the notional benefit as of now.
For the
Promoted,
notional
he is
benefit-
promoted.
Promoted and his service was regularized. So for national benefits, he had to challenge his regulation
I
order.
the prayer is there in the writ petition.
Where is there
I
the
need to
challenge
challenge.
and regulation order?
2 minutes. This is an old computer.
Lordship is not.
It's never, my lord.
On recommendation of the Assam Public Service Commission. Respectfully, is hereby regularized with the date of joining. When was he promoted?
2020. 21st of
Petition
November.
Manos.
That I have given to my lordship.
He'll get it from 20 only.
20.
Then?
Yes. Then what is his prayer, lordship? They are saying he has, he was notional, but that for that they will have to,
Benefit from the date on which my juniors got promoted.
and he will have to
Promoted.
challenge the regulation order.
Lordship, today I'm handicapped, my lord. The five.
Madam, 2 things.
My lord.
You have retired now.
No.
You have not retired.
Not retired.
You are still in
Lord,
service.
What happened?
National benefit he wants from
What
the
happened,
date of
my lord?
No,
promoted
no,
from
no, no,
the
just a minute. 55 in 2019.
2019.
6 years. You have retired.
But my client just minutes back, I called him up.
You confirm that.
Yes, after the BU holidays, a fixed date be given. Because today I'm handicapped.
Okay. On the
Fine.
prayer of the Learned, Miss MD Bora, Learned Standing Council,
transport.
uh,
Transport.
Transport Department, on instruction submit that the petition hearing was promoted to the post of
District transport.
Enforcement Inspector
Yes.
under Regulation 4D wide and notification dated 21/11/2020. Such promotion of the petitioner was regularized on the same being approved by the APSC wide a notification dated 12/6/2024. She submits that the petitioner has been released all his due promotional benefits with effect from the date with effect from 21. Have been released all the due benefits in terms of the notification dated 21/11/2020. Ms. B. Bhuya, Learned Senior Counsel, appearing for the petitioner, submits that she be granted a week's time to obtain her instructions in the manner with regard to the said aspect of the matter projected by the Learned State Council. Also, registry accordingly, registry to list this matter again on
28th or 22nd, my lord?
20 pari, 21,
22, my lord.
22 pari, 22/1/2026.
Lordship. Lordship, he
you
was
apply,
promoted
madam?
to district transport officer from EI.
So
to
regarding
DP.
notional benefit, I might have.
No, lordship has observed.
This post of question, District Transport Officer.
Lordship. Obligement.
Obliged.
There was a coordinating bench judgment passed by the Honorable Justice Sanjay Kumar Medhi. If Lordship may kindly look at.
On the same point.
Yes.
No, on the same point, on this selection, there is a judgment. Why should I go beyond that?
And in fact, my lord, there was a judgment passed by the division bench also.
A series of writ appeals were disposed of, my lord.
Whether writ appeal against that was the,
The same, maybe, my lord, there are lots of writ appeals. If lordship may kindly go through it. Second lordship.
yes, Mr. Dhor, what happened to that decision? Any appeal against that?
No.
Huh? No appeal.
So far, I know, my lord, no appeals. Because they are they will know better, my lord. They are the council of the.
Already council.
On that writ petition number.
16 of
Yes,
2011.
6 of 2000.
You already council.
Yes, madam.
And then?
And they are preferred.
How can you discriminate between your clients? No, bad. Two clients you will dismiss, one client you want and allow other. No, I'll not allow that.
Where in the writ petition they have referred to this, my lord.
Give me the order. Go up on appeal.
My lord, in fact, my lord, coordinating bench judgment, my lord. Amota, Sanjay Kumar Medi, Honorable Justice Sanjay Kumar Medi passed the order on my.
Same selection.
Not same selection, on the same.
Array, that is the difference. Here in this case, he has dissected that. How the posts were coming on record, how this election came into an end. How can I go beyond this?
In fact, my lord, Sanjay Kumar was also discussed here in this case.
Here also, Sanjay Kumar was discussed.
Here also. My lord.
Sanjay Kumar, Shyam Kumar Chaudhary, I think that is Shyam Kumar Chaudhary. That is discussed. Okay, we'll pass the order in the signal.
Lord.
Who is appearing for the government?
Um,
What is this? Why? You yourself have increased it to 300. Now, why are you not giving her? Why are you limiting it to 294? That is the case. 300, 294. Huh?
So, is the updated status as part of also last order also they were supposed to all the parties were supposed to appear for the mediation lawsuit.
Forget mediation. Mediation is not. Will you agree in mediation? You will not agree. So forget mediation. That is a step we tried. You did not fulfill. Now, the law is encashment, leave encashment up to 300 days.
Yes, that is yes.
Law.
From 200 something.
If he has 294, if he has 300, give it to him. If he does not have, reject it. Why keep this matter pending here? That is your only grievance, madam?
Let's say I may I get some kind of instruction?
2 o'clock. So, Davildar, how are you denying that benefit to the petitioner?
He didn't.
Your OM of 2018 clearly says that what is the other benefits required? A13. That is the passing of if attending those refresher courses. In your affidavit, you say that the one committee was constituted and the committee had taken some decision. Where is the corrigendum issued? And if the corrigendum issued, whether it is issued with retrospective effect? No, no, you
And
tell me.
Lordship, the
You're very
similar issue-
emphatic. Now you tell me.
Similar issue has been Lordship dealt with in a batch of petitions, Lordship, and Lordship, it has been
Allowed,
no, Lordship,
dismissed.
dismissed, Lordship. Batch of petitions was discussed. Everything was discussed in that. Lordship. Paragraph 21 is the relevant one.
No, no.
Paragraph 21.
Mr. Sharma. No, no, your office memorandum is thereafter. This judgment is of 2016. Office memorandum is of 2018.
Lordship.
Then,
Then it was Lordship clarified, Lordship.
huh?
At page 14, Lordship.
Pa-
145 of the affidavit, Lordship.
140?
5 of the affidavit.
145.
Yes. And 146 is the irrelevant, Lordship.
145.
146 is the relevant, Lordship.
146
is the relevant, Lordship.
Minutes.
Yes, Lordship.
This is 2320.
Yes.
Where is the corrigendum in pursuance to this? This is just the minutes
Yes,
of
Lordship.
meeting. Where is the corrigendum?
Corrigendum, Lordship, yes.
If there is no corrigendum, that will hold the field.
Yes, then Lordship, I'll get.
Where is the corrigendum?
Corrigendum is, Lordship. The corrigendum should be included present.
This is just a opinion.
Yes, Lordship.
That you accept this and you amend your earlier thing. You will have to issue a corrigendum.
Yes, Lordship, I'll get it.
2 o'clock. If there is no corrigendum, she is through.
Lordship, can
Because
it be
that-
tomorrow, can it be tomorrow?
Again, I'll have to read. I'll
No,
forget.
no, Lordship.
I'll forget.
I'll not travel, your Lordship. Tomorrow, Lordship, that I'll bring the corrigendum.
Lordship. Mr. A.R. Tabilda, Learner Counsel for the petitioner submits that the matter be taken up on Wednesday,
Lordship.
7/1/2026, on which date he shall apprise this court as to whether
Yes, that's
any
mentioned.
corrigendum
Yes,
has
that-
been issued,
Yes.
and that too with retrospective effect in pursuance
Yes,
as to the
Minutes.
minutes of the meeting held on 2/3/2020 of the committee constituted by the government to examine the anomalies purportedly existing in the OM dated 7/1/2018.
Lordship. Obliged, Lordship.
Yes, Mr. Fukon.
My lord, this matter, my lord, you have already filed an affidavit on September 25. my lord.
Forget your affidavit.
And my lord, as per our affidavit at page 89, my lord, we have basically stated, my lord, that
Who is this special committee? What is that committee? What is that jurisdiction of the committee in the rules? In the act?
my lord, the
But the SSA has now filed an affidavit. Mr. Fukon, SSA has filed an affidavit wherein his name is already all along there.
my lord, as per our this records, my lord,
That is the case, Mr. Singh.
the escort, my lord, the escort generally is maintained by the SSA only, my lord.
You might have got it from some other place. We don't know. Maybe that committee has a very big power. It can
Well,
go
whatever-
inside the computer and generate.
My lord, they have
But the
data.
SSA authorities say his name is there. Okay. Mohammed Abdullah and Abdullah.
My lord.
That is the only difference.
Name, my lord, names also, my lord.
Oh, Mohammed Abdullah is there. That is how they have given it. You don't have that.
Should the affidavit by the
You don't have that. Okay.
filed by the SSA, my lord. So
Oh.
I'll-
Mr. A. Fukan, Learner Counsel for the petition for the Learner Standing Council, Elementary Education Department submits that he be given a day's time to receive instructions with regard to the contentions raised by the respondent number 8 in the affidavit filed by it. Prayer accepted, registry to list this matter, Biruspati Balakodia. 8.
Obliged.
We are allowing it. You satisfied?
But technically, my lord, the names obviously are.
That I'll give you a way out to do that.
My lord.
The power is there in the rules.
My lord.
Huh? You need not have
Correction.
a committee for that.
My lord.
The SSC or SLC, whatever it is, it can go and get the records from the school.
And my lord,
Have inquiry made, rule 14 or 19. Use that.
we generally go by the, my lord, by the whatever DIAS data is given to us, my lord. So that is why that particular.
You say DIAS data not there. Not there and wrong entry are two things.
My lord.
You say from 2011, his name is not there.
My lord.
But the author of the DIAS data says, no, his name is there. Till 2014-15. 15-16, a difference is there. So what is this committee of yours doing? What is the data? On the next date of listing, Mr. Fukan shall apprise this court as to the data considered by the purported joint committee for arriving at a conclusion that the name of the petitioner was not included in the DIAS data
In 2011.
after 2011-12. It is to be noted that the respondent number 8 in his affidavit has brought on record the fact that the name of the petitioner figured in the DIAS data from 2006-2007 to 2014-15 as Muhammad Abuullaha, huh? Yeah, page 96 of Silabanam. And with effect from 2015-16 as Abdullah. So, however, a contrary picture is seen to have been projected by the joint committee in its report, which finds play mention in the order dated 11/3/2022 passed by the Director, Elementary Education Assam. Thursday, I want that instruction. Which is the data your special committee had considered. Maybe Mr. Chaudhary is giving us a wrong data under threat from Mr. Sheikh. Maybe. So you give us that. If not, on Friday, I'll have the entire batch here. This is too much. First and foremost, how can you constitute a committee when it is not envisaged in the Rules Act? A solemn process. Mr. Fukan, have your instruction.
Obliged.
Yes,
Payment of salary.
area salary.
They have not given me on the basis of no work, no pay, whereas there are many number of litigations going on. They themselves gave everything.
Yes.
Lordship, in this matter, the secondary education has filed their affidavit. The school was basically provincialized. Initially, we thought that the secondary education.
No, not
would be made part-
provincialized, amalgamated.
Amalgamated, my lord. Apologies, my lord. Amalgamated on 2017. So, my
But
lord,
at
now.
that point of time, in terms of the directions passed by you,
My lord.
he was working in some other school. Continued to work there. It was only in 22 that you asked them
My
to
lord.
leave. So, prior to 22, he was working there. So now you are in that amalgamated school.
No, Lordship, I was not 22. I was given a posting. I'm in a different school, not amalgamated school.
Where are you now?
Madhav Das school, there's in town Panigaon only, Lordship. Mahendra Das Vidyapit ME school. Because
Mahendra
Das ME school, Vidyapit ME school. And I joined there from 7/6/2022.
and you are working therein.
Yeah,
You're
since.
getting your
Yes,
salaries.
7/6.
Yes, Mr. Fukan.
Lordship, I'll get my instructions, my lord.
Not
Because-
instructions. No
My lord,
instructions
because
are-
of the fact that the affidavit was filed by the secondary, my lord, since they have said that though it is amalgamated, I'll have to get my.
Where is that show cause notice?
The one where I'm challenging, Lordship?
No, the earlier one. Earlier challenged. The one you challenged before this court earlier.
Lordship. There was no show cause, there was a blanket order passed for all the teachers who have been attached to go back to their original posting, Lordship. The thing started from there, 2017. There was no show cause, Lordship. There were,
Maybe I'm wrong, just one.
maybe I'm wrong. Lordship, Lordship, I'm sorry, Lordship. Annexure 23, page 97. Page 97, 98. I'm absolutely sorry, Lordship.
We are not wrong that.
Yes, Lordship, I'm wrong, Lordship. That's all. Lordship cannot be wrong.
Huh.
Yes, yes, that's for sure.
Mr. A. Fukan, Standing Council, Elementary Education Department, shall apprise this court on the next date of listing as to why appropriate directions would not be issued for regularization of the period of absence of the petitioner with effect from 1/3/2019 to 8/6/2012, along with release of his due salaries for the said period. Inasmuch as it is the contention of the petitioner that he, during the said period, was working as an assistant teacher in
Town Panigaon ME School. I
Panigaon ME School.
was not working that time. I was going to the school. I was not allowed to work because there was the
I cut it. Mr. A. Fukan, Learner Council for Learner Standing Council, Elementary Education Department shall.
May I just come in, Lordship? That is already done, Lordship. This order, Lordship had already given earlier, and they had bought up papers showing that their stand is same. No.
Okay.
That this direction is not
Okay,
required.
that letter that they have.
Yes, Lordship. This direction is no more required. They have stick to that no work, no pay. Lordship will not give them any direction. Lordship will hear on the matter because they already said they cannot do it.
No, that is by the inspector of schools. You are never under the inspector of schools.
No, Lordship. Director of Secondary Education had given a written thing, Lordship. Lordship, there is an order of your Lordship. I've missed the date by which Lordship wanted inquired why regulations was not done. Then in that view, they had bought a
Okay. 31/10/2022. How have you come to this conclusion? No work, no pay. Because he has given a justification that he was going to the school and the school authorities were not allowing him.
Man. That's the standard.
So you have to determine that aspect of the matter. You have not determined it.
Therefore, my lord, I'm seeking some time.
Okay, for
I'm
that.
seeking some.
Mr. A. Fukan, Learned Council for the Learned Standing Council, Elementary Education Department submits that he be granted a week's time to complete his instructions in the matter.
Can it be on 30th of January?
Why 30th? We will give you in 31st of March also, no problem. But at this time, I want something. 31/2025, 26. On the next date of listing, the Learned Standing Council shall apprise this court as to, without holding any departmental proceedings against the petitioner, how his period of absence from 1/3/2019 to 8/6/2022 was held to be unauthorized. Slowly, we'll come there. Slowly. If Mr. Fukan has got the message, he'll take necessary action.
the impugn order itself was on
You
the
will
face.
be in trouble. If he does not get it,
Yes.
they'll be in trouble next day. You will have the order.
No, Lordship, may just kindly see that
I've seen.
impugn order. The same day BEO writes letter, brings, and the same day without going. Lordship, just for kindly.
I know I've seen it. The letter of the district, what do you call that? District authority.
Day.
Okay.
Then that period also is wrong. That they mentioned 22. Lordship, everything is wrong in that which
Order.
I'm challenging.
Period should be from
1/3/2019 to 8/6/22.
8/6/22.
Well, Lordship, my order.
I have
Yes,
recorded.
yes.
We'll see on the next. Don't worry. 30. Mr. Fukan, have your instructions.
Obliged, Lordship.
May I please, Your Lordship? I have been fighting for this LDA post since 1999, my lord. And department has been doing everything but not giving any relief, for which 1,50,000 cost was imposed by last order. So thereafter, they come with one point, then there were some corrections. They also said that we will send it to the forensic, but they are still filing no affidavit,
Lordship,
whether
the
those that
instructions.
things are happen to anything. So, my lord, first of all, they are duty bound to check whether those things were done by me or on my behalf.
Subodh Kolita was appointed.
Yes,
His appointment now has been set to naught.
that is
Cancel.
correct. That is
That's the end of the matter. Yes, why not forensic science?
Lordship, the instructions are awaited, Your Lordship.
Forget
I'll have to,
instruction. This order was passed in
23.
23.
26 June 2020.
Where is your this department? Where is your this directorate? Kailipara only.
Ye Lordship,
Forensic Science Laboratory is just
Yes.
next door.
Lordship.
Now tell me, why should we entertain this? What is the error?
My lord, first of all,
First of all, this point is taken in the earlier order by the respondents.
my lord,
Okay,
that is correct.
this court had noticed it, but because Subodh Kolita was given that benefit, this court said, no, this cannot be 1,50,000. But this court never interfered with Subodh Kolita, nor directed for giving you appointment. Then they have come up with this plea. What is the error here?
My lord,
And this is a recruitment process of
1998.
98.
Yes. First of all, my lord, in the year 1998, Subodh Kalita was appointed. It is
It
admitted
is
by the
gone now.
department.
It is gone.
He was upgraded.
Upgraded, illegal. Now the order says he is gone.
That post is still vacant.
Vacant. Fresh selection.
Since 98.
Tell me one thing. All these things have been said. This court never interfered with the appointment of Subodh Kolita. Right? Subodh Kolita was upgraded as assistant teacher only because of his recruitment as LDA.
Well,
So that selection had already concluded.
but
There can be a fresh selection process.
But department have already admitted their fault that Subodh
Forget it.
Kalita, that selection list was wrong.
Forget it. Now Subodh Kolita is also gone.
My lord.
That whole selection.
I'm not with Subodh Kalita because he was already upgraded.
No, he's gone now. He's
That is correct after so many attempts, my lord.
fine. He's gone. Finally.
Yes.
You succeeded.
No,
But-
I am not succeeded because my aim was to
No,
get
you
appointed.
succeeded in getting the post vacant. How old are you now?
45, my lord.
45.
Yes. And that recruitment process earlier, that is already.
What happened to the subsequent recruitment process?
That is.
Madam, what happened to the subsequent recruitment process?
By the.
Lordship,
Say.
it was
stayed
stayed
in the year
Your Lordship.
2016.
It was stayed.
Thereafter, it was, my lord, directed to consider my matter. My lord, kindly come to page 77, my lord. The relevant portion of the order.
Hmm.
'38 paragraph, my lord. After the compliance of the order dated 2006, in WPC number this and that, the respondent number 1, Commissioner and Secretary Education Department as directed above, respondents in the Secondary Education Department shall take appropriate step in accordance with law as to whether it should.
Okay, the direction is whether it wants to proceed with the earlier process,
Yes,
right?
yes.
It says no. What is the mistake? This is only a writ code. We are not going to take any evidence here.
It is correct, my lord. But thing is that
If that is correct, that is the end of the matter.
no, I think, my lord, that is not the end of the matter, but because the respondents by this impugned order made the matter open, my lord. They have not come to a conclusion.
I'll close that. Don't worry. That ozone hole that is open, I'll close it.
But the thing is that for my
The
for
closure would be that they will be permitted to take the process, either the earlier process to a logical conclusion or initiate a fresh process. Anybody So both you, anybody can participate subject to you fulfilling the eligibility criteria of age and qualification. That's the only order I can pass.
Qualification is there. I think.
Age may not be there.
Yes. But they must come to a conclusion that.
That's
that
why
thing
1,50,000 has been paid to you. I think that is enough.
No, that is already, the review was there and that is already, my lord,
Reviewed.
exempted. Yes,
But you have not brought it on record.
that is subsequent event, my lord.
Okay.
But that is exempted, my lord.
Symbolically, we are dismissing it. Anything more?
Only thing is that the department is duty bound to do all things, inquiry if anything. If after inquiry, they come to a conclusion that that thing was done.
Subodh Kolita has been removed.
No, Lordship.
Huh?
Yes, yes.
Are you
yes.
sure? I can record your statement to that effect.
Lordship, then after some time, Your Lordship, let me.
Sure.
In the instruct.
Just make a statement that Subodh Kolita is no longer in service.
Lord.
He is no longer in service.
I think so, my lord, because he was removed. Thereafter, he came to file one. writ
And
petition,
what
I
is
think.
the stage of the earlier selection process? There is no stay order here. In this writ petition, there is no stay order.
2015 was.
No,
state-
no. The present writ petition, 23.
No.
No stay order. What happened to that post? Just get me these two instructions.
It's not come.
If you can't get it, we'll have it on tomorrow or day after, whenever.
Lordship, that will be better, Your Lordship.
On Ms. D. Musahari, Learned Council for the Learned Standing Council, is Elementary Education Department submits that she be given a date's time to complete her instruction with regard to the fact as to whether Subodh Kolita, that is the respondent number 495.
In this matter, I have
It's
not.
not been paid.
As to whether Subodh Kolita, who was earlier appointed as LDA in the school, is continuing either as LDA and or as assistant teacher in the said school. She shall also apprise this court as to whether the selection process that was initiated via advertisement dated
11, 12, 15.
by advertisement. No, that is the first one, your advertisement. So 98 is yours. 11, 12, 15
Yes, 19.
has been taken to its logical conclusion. Thursday.
Lordship. Oblation.
Yes, Mr. Chaudhary.
May it please.
Hmm.
My lord, the petitioner under the Benchmark Disability Act applied for the post of assistant engineer civil.
What are you? What
My lord,
disability you have?
my lord, locomotor, both of us, I think.
Yes.
Both of us are locomotor, 35, 36, both. My lord, thereafter, my lord, we
Advertisement is dated
advertisement dated, my lord, 15/3/23, my lord,
15/3/23.
23. There was a
12
corrigendum.
posts, 12 posts of.
My lord, 15.
Initially,
Initial 12, then the corrigendum, it becomes.
Now initial only. And the breakup was also given there.
Breakup
And
was
for
also.
locomotor, it was 3.
3. And one was, my lord.
Autism. No,
No.
autism and locomotor 3.
3, my lord.
Then it was increased by a corrigendum dated.
My lord, corrigendum dated 3rd August 2023. No? 3rd August.
Yes.
To 15.
15. My lord, number of vacant posts for blindness was 2. That includes 1 backlog. And my lord, then for deaf and hearing, 5.
For locomotor.
Locomotor, my lord, there was 3 and 1 for backlog.
So total 3.
Total 3, the
4.
number of vacancies.
Total 3 or total 4, Mr. Doctor?
Total 3.
3.
That affidavit of yours, you have brought in a corrigendum.
Yes.
Therein you have given up a breakup.
Page 34, Lordship, in the.
If I know that much, so then I would have been
Lordship,
somewhere
blindness
else.
and low vision is 3, Lordship.
Annexure
2.
C, Annexure
Yes.
C.
Next charge sheet. Blindness and low vision 2, deaf and hearing impaired 5.
No, I'm not on. that.
Affidavit.
Locomotor total 3, including one backlog.
You come to page 69.
Lordship.
Seventy.
70, Lordship.
Here locomotor disability is 3,
Including one backlog.
including one.
One backlog.
Yes.
My lord, written test we have gone through. Then, my lord, the list that has come out, page 37 in my repetition, annexion 9.
Repetition, Nilimpatam.
Nilimpatam.
37.
37. My lord, serial number they have given, locomotors will appear in serial number, my lord, 234 at page 42, 235, 237 and 238. These are the locomotors, my lord. And my lord, next line in the notice board they say.
No, this Aliaman Firdaus Ahmed is also a locomotor.
Locomotor, my lord. That is I am saying, my lord,
234, 235,
237,
238, 4.
238.
4.
My lord, NB they have said 6 vacancies pertaining to that disablement could not be filled up.
This is hearing and or some autism, one autism or something.
My lord.
Were not filled up.
My lord, in the affidavit they have stated, my lord, autism they could not fill up. My lord, in page 48 they have said, page 48 of their affidavit, under the above fractional circle, total 6 posts, 3 vacancies of deep and hearing, and 3 vacancies of autism could not be filled due to non-availability of candidates in the respective.
So locomotor fully filled up.
They say that it is fully filled up.
So what is your case?
My case is, my lord, my case, my lord, because there was a order from this court where the affidavit filed, rejoinder filed in the another writ petition will also be considered here. That is there, my lord. Our case before this honorable court is, my lord, if we have stated therein that total, my lord, blindness, there were total.
Why are you bringing in blindness?
Because my lord, that is relevant, my lord. That is, I will place it, my lord. Because I will place it, my lord.
Fine.
My lord, subject to correction, my lord. I just,
fine.
My lord, there were 2 + 1 without absorbing, that is in the rejoinder we have stated. Number of vacancies 2, 1 backlog, total candidates interviewed were 5.
For blindness.
Blindness.
5.
Locomotor, total candidates interviewed 22. Number of selected candidates 3. Number of vacancies 3. That includes 1 backlog. My lord, deaf and hearing, total number of candidates interviewed 2. Number of selected candidates 2. Number of vacancies 5. That backlogs there were 4. And autism, there were number of vacancies 5. Backlogs there are 4. So from, my lord, total these 6 were left. My lord, these backlogs were inclusive of the previous year. So, my lord, subject to correction, my lord, here they cannot take it for the next year because they had to abide by section 34(2). They had to interchange the, my lord, vacancies. That is a mandatory, my subject, my lord, because you lost 34(2). They have to interchange because this is of a previous year's backlog. Again, in the next backlog, they cannot, my lord, carry forward. They had to interchange the vacancies.
Advertisement is of dated,
my lord, 23. 15/3/23. And they have stated that these backlogs, and we have made the clarification in the rejoinder, my lord, how this has come over. These backlogs includes the previous year's backlogs. So they cannot, my lord, in a subsequent year, they cannot carry forward. And they have relied upon on one notification saying that 8.1 will only give them 1% permission for interchanging. But they have not looked into the notification of 8.3 and 8.4. That is also in relevance to section 34. Section 34(2). And my lord, though your lordship will not be bound by it, my lord, going through the provisions of law, I got to some other High Court judgment where it says that 34(2) is a
Okay,
mandate.
now show me that, okay, we accept that this 6 posts should come in.
Well,
Let us accept your that interchange of vacancies because this is inclusive of backlog.
backlog.
And the backlog being there, a second year, it would
cannot
not be further carried
carry
forward.
forward.
It will be
Interchange.
interchange. Now, deaf and dumb, the backlog is the filling up is
Well,
page 50. Where was that statement made?
my lord, in the rejoinder, my lord.
No, in the affidavit.
Affidavit page, my lord, 48. Because they are not sufficient.
Okay, now you come to the corrigendum.
Well, my lord, corrigendum.
So autism, 4 posts,
Backlog.
and deaf and dumb, 3 have been filled up.
My lord.
So 3 have been filled up for autism,
My lord.
right?
Well.
3 have been filled up for
Locomotor, 3 posts.
no. 3 have been filled up for locomotor, the deaf and dumb, and 3 have been filled up for autism.
My lord, if your lordship just, I'm troubling your lordship to this clarification we have given in the rejoinder, my lord. Your lordship may look into the rejoinder file in 650623, where we have given the, my lord, reply, and my lord, at page 5, para 6 onwards, we have given the reply. In the rejoinder filed in, my lord, 650623, para 6 onwards. Okay.
Okay, where is your rejoinder?
Rejoinder in, my lord, WPC 650623. That will be considered for both the writ petition.
Okay, fine, no problem.
Para 6.
Page
5. Para 6. Relevant will be para
Abu Ahmed Nurul Hassan Laskar. Internal page?
Internal page 5, my lord, para 8.
No, this does not, they say only 3 posts of autism
No.
were not filled up. That means 2 were filled up.
2 were filled up, but
So backlog, there was 5 posts advertised.
5 posts.
4 was backlog.
My lord.
And for deaf and dumb, 5 posts advertised,
My lord.
4 were backlog.
Backlog.
So deaf and dumb also, 3 were appointed.
My lord.
Hmm?
My lord.
Now, why will we not take it against the backlog? That 1 post was vacant.
My lord, I have not followed your letter.
5
My lord.
is also inclusive of 4 backlog.
My lord.
3 were filled up.
Defendum.
Defendum.
Defendum. My lord.
Right?
5, my
2
lord.
were filled up.
2
were filled up.
2 were filled up.
3 is left. Why will we not take this 2 against the backlog vacancy?
My lord.
Because it's only the backlog vacancy that can be carried forward.
Backlog. My lord.
So 2 can be carried forward from deaf and dumb.
My lord, here their appointments in the affidavit they have said, the appointments what they have stated, my lord, in page 47. Page 47, 3. Deaf and hearing 2 were filled up. Roll number, Aslop, general, accommodated in open category.
Fine.
And my lord, then roll number such and such accommodated in SC category. Due to non-availability of candidate under deaf and hearing, no further recommendation could be made in the said category. And in ostracism, no candidates available. As such, no candidate could be recommended under ostracism category. There was no appointment in the ostracism. And ostracism, there were backlogs were 4.
Yes, Mr. Doctor.
Lordship, we have made, Lordship, can I have to bring Lordship to section 34 once, Lordship? Of PWD Act, Lordship, 2016.
16.
Right of person with
Persons with
disability.
difficulty and disability.
Section 34, Lordship.
30?
34.
34.
Right of persons with disability. Lordship, just every appropriate government shall appoint in every establishment not less than 4% of the total number of vacancies in the cadre strength in the each group of posts meant to be filled with a person with benchmark disability, of which 1% is shall be reserved for person with benchmark disability of clause A, B, C, and 1% for the person with benchmark of D and E, namely so and so, Lordship. Provided that, Lordship, got it. The reservation and promotion shall be in accordance with the such instruction as are issued by the appropriate government from time to time. Under this, Lordship, proviso, Government of Assam has promulgated one office memorandum for giving effect to the reservation with benchmark disability. Now, Lordship, subsection 2, Lordship. Where in any recruitment year, any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability, or for any other sufficient reason, such vacancy shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also no suitable person with benchmark disability is also available, is not available, it may first be filled up by interchange among the 5 categories. And only when there is no person with disability available for the post in that year, the employer shall fill up the vacancy by appointing a person other than the person with disability. Now, Lordship, that interchange provision has been included in that office memorandum also. Lordship, my affidavit in opposition, Lordship, page 71.
Page
71. This is the office memorandum for reservation of post of person with benchmark disability and other concessions, Lordship. Now, clause 4, Lordship, 4.1. In the category of post, Lordship, got it? Which are identified suitable for person with benchmark disability, the person with benchmark disability cannot be denied to right to compete for the appointment by direct recruitment promotion against an unreserved post. Such a person with benchmark disability can be appointed by direct recruitment promotion against post not specifically reserved for the person with benchmark disability, provided that the post is identifiable post for person with benchmark disability in the relevant category. 4.2. Person with benchmark disability selected without relaxed standard along with other candidate will not be adjusted against the reserved share of post. The reserved post will be filled up separately from among the eligible candidate with benchmark disability, which will thus comprise of a candidate with benchmark disability who are lower in merit than the last candidate in merit list, but otherwise found suitable for appointment if necessary by relaxed standard. So, as per my understanding, if any candidate of person with benchmark
That is
disability,
why in the locomotor category,
yes,
you have brought in
two
two.
candidate has been Lordship, one candidate, Lordship. Now, Lordship, clause 8, Lordship. Direct inter-C exchange and carry forward of reservation in case of direct recruitment promotion, where in any recruitment year, any post cannot be filled up due to non-availability of suitable person with benchmark disability or for any other sufficient reason, such post along with category of reservation shall be carried forward in the succeeding recruitment year And if in the succeeding equipment year also suitable person with benchmark disability is not found available, it may first be filled by interchange among the following 4 category of disability at 1% each to each category. So, Lordship, in any category, Lordship, we can interchange only 1%, Lordship. Under that provision, Lordship, may I draw your attention to page 46 of my affidavit in opposition, Lordship. That the category-wise breakup, Lordship. Lordship got it.
No, I'm sorry, but at 1% each to each category. Category here would be those four.
Four, Lordship.
Blindness,
Lordship.
deaf and hard,
Lordship.
locomotor, autism.
Lordship.
Four. These are the categories.
Yes, these are the categories. For category A, B, and C, 1%. That 4%, out of that 4%, 1% is for A, B, and C as per section 34. And for D, both autism and multiple disability, for both
One,
is
one.
only one, Lordship. And interchange is permissible only 1%, Lordship.
Okay.
Now, Lordship, was page 46. That in case of blindness and low vision, there are total advertised push was 2. Out of that, Lordship, 2, 1 is backlog, and total 5 candidates we found for interview. Out of that 5%, Lordship, 1 candidate, Arnab Jyoti Sutradhar, who was an open category candidate, was recommended in the merit basis, Lordship, not as a PWD candidate. Because his merit mark was higher than any other merit candidate, Lordship. He has competed in merit, Lordship. So his post was not adjusted against reserved category of PWD, Lordship. Now, Lordship, rule number 40131, Kiran Dole and Kakoli Sharma, these candidates, they are adjusted as a PWD candidate, Lordship.
No, Kakoli Sharma is again open category.
No, Lordship.
At serial number 24.
No, Lordship, they
You
were
have not written the merit basis.
Yes, they were not on merit basis. They were adjusted in open category.
Open category means by giving PWD.
PWD, Lordship. Horizontal eligibility, Lordship.
Now forget it.
Lordship.
Now after doing this, how many posts remain out of that backlog?
Out of that backlog, Lordship, total out of
you come to page 69.
Lordship.
70.
Lordship.
Total backlog post is 4, 8, 9, 10.
Lordship.
Right?
Total 6 posts in 3 vacancy in deaf and hearing impaired and 3 vacancy in
Total
autism.
backlog vacancy, come to page 70. We are only concerned with backlog only. Come to page 70.
70. There are 4
Backlog
vacancies.
vacancy is 8, 9, 10. These are carried forward vacancies from the
Yes.
previous recruitment.
Yes.
10. Now,
Page 70, Lordship.
70.
70. Lordship.
10. Backlog only.
Yes, yes, yes. For 10.
Right?
Yes.
Out of 15,
Out of
10
15,
posts
10
are backlog.
backlog.
Now, blindness, you made how many appointments?
Blindness. Blindness 2.
2.
2.
So, blindness, there is no backlog.
No backlog.
Filled up.
Filled up.
Deaf and dumb.
Deaf and dumb, Lordship, 4 posts they were there and 2 were Lordship appointed.
2.
2.
Locomotor,
Locomotor, Lordship,
full. All 3.
2. 3, all total 3, but 2 go under reserved category.
Fine. So, there is no carry forward here. Autism, none.
No.
Huh?
Autism, Lordship, no. We could not.
No.
No. No candidate available.
No candidate available. So, you have carried forward 6 posts which were carried forward were not filled up.
Not filled up.
So, open for allotment,
Interchange.
interchange.
1%.
What 1%?
As per that section 34 and the
Now you come to the main
8.1.
section, 34.
8.1.
2.
2.
You cannot go beyond this.
Yes, Lordship, prior to that, Lordship. Apart from that, 3 posts already fill up under locomotor category. 2 page, Lordship, table con, Lordship. After that, the end of the table, E, Lordship, page 47. Seven. Plus E, as per provision of clause 8.1 of the OM dated so and so, 1% of the total advertised 244, that is 2 posts, were filled up by candidate from locomotor category. That is CL number 237 and 238. That 1% that intersection has been done.
Now you are playing around with words.
That's it.
You say they were not appointed in the earlier page as PWD candidates.
No.
Come to that earlier thing.
Yes, Lordship. No, EP that is, Lordship, in case of blindness, Lordship. Rule number Arnab Jyoti Sutradhar.
Locomotor, Deep Paul, Saurabh Biswas, Lokheshwar Deep.
No, they were under the PWD, Lordship.
PWD.
In case of blindness, one was in merit.
No. I'm on locomotor.
All 3 were against adjusters against, Lordship, PWD candidate.
And where is this Alaman and Deepjyoti coming in as?
Lordship, they are, yes. Lordship, they are by 1% interchange.
From 1% of what?
Of total number of posts, Lordship.
Of the carry forward posts or the total reserve, total post advertised?
Total post advertised, Lordship.
Show me that. 8.1. Now this is getting interesting.
Lordship, I am reading again, Lordship.
And this is error. So if that 1% of 244,
Lordship,
you have taken.
Lordship.
Oh, you mean to say you have taken 1%,
1%.
and 2 persons have been appointed, no further can be appointed.
Lordship.
Right?
Lordship. And from locomotor, because
how can it be total advertised vacancy? 1%.
Otherwise,
come where in any recruitment, any post cannot be filled up due to non-availability of so and so, or for any other sufficient reason. Such post along with category of reservation shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also suitable person with benchmark disability is not available, it may first be filled up by interchange among the following 4 categories of disabilities at 1% each to each category.
from any,
So six
category.
6 posts.
Yes.
1% would be?
Not for 6 posts, Lordship. Out of my understanding, out of total vacancy, I can pick up 1%, and that 1% from any category, Lordship. Because here, those 2 candidates, Lordship, their mark were higher than.
Will it be a situation like this?
Lordship.
You have filled up 3%, whatever you could.
Lordship.
Now the backlog remains.
Lordship.
Now you will have to have a list of PWD candidates.
Lordship.
Locomotor, blind, all.
Lordship.
Whoever is top, they will be appointed.
Lordship.
We'll see. Interesting.
Yes.
Anyway, any matter of Mr. Chaudhary cannot be but interesting.
It will be a pleasure on my part to place service better before your lordship.
No. It's a new thought process for me in this.
Yes.
I was thinking on a different line.
Lordship, that question.
Now that I have.
That question also is like yesterday night while we were discussing in this case that Lordship has pointed out. That point.
I was thinking on that line. So let's.
May it please, your lordship.
Yes.
My lord, as my friend has shown 8.1, he was trying to refer to your lordship about 8.3 and 8.4. Page 73. In the affidavit. Page 73, my lord.
Yes.
I took it up. Judgment.
This is basically
34.
34.
My lord, and if your lordship permits me, not binding, my lord, what I have understood from
No,
that is,
please.
my lord, this judgment from para 9 onwards. Para 9 onwards.
PB means
My lord,
PD?
PWD, should be PWD, I think. my
No,
lord.
no, it's PB, PD.
Post PB, PD. PV in the number one, PB and PD. Person's benchmark or person disability, something like that. No?
Persons with benchmark disability.
Disability. Then ultimately finding
So,
out,
Mr. Chaudhary, according to you, there are 6 posts.
my lord,
How will the 6 posts be now apportioned between the other categories?
vacancies, my lord, my lord, first of all, my lord, they say that this notification is pursuant to the
Forget
proviso
the
of
notification. Let us only stick to 34.
34, my lord.
Now we have pool of 6 posts.
My lord.
Huh?
My lord.
Now this has to be distributed amongst the other 2 categories,
My lord.
right?
Available candidates.
Available candidates. Now, how will this available candidates be determined? Since who will be now recruited against that? What
Well,
would be the procedure to be followed?
When, my lord, they will ask for interchanging, they have to seek permission from the government.
Let us say that permission is also granted.
And the government will provide them the procedure under which they will.
No, the government cannot. There has to be some set parameters
Well,
somewhere.
Well,
Now there are 6 posts.
well,
Let us say, how will this 6 posts be apportioned
well,
to your, what do you call that, locomotor and blind?
my lord, because
Locomotor and blind.
blind,
Because there is nobody in autism
my lord,
and there is nobody in deaf and dumb hearing.
defender,
So these are the 2 categories that are now available.
my lord,
Let us say that all the 6 posts have to go.
my lord. Then, my lord, the 3 each, that will
3 each.
my lord.
Now there is an underlying factor in Mr. Dotto's affidavit.
My lord.
He says that 2 candidates were in addition to this recruited.
In addition to this. My lord, what is the cutoff mark and how they have taken those persons from where?
But you have not challenged that.
My lord.
They have filed an affidavit. They have made you have not disputed that position.
My lord.
If you come to their affidavit at page 47.
Page 47.
Last line.
And they have said blindness, my lord, in blind, one is general without taking into consideration that benchmark disability.
Forget that. That will not be a backlog because we'll consider it as backlog. That will be in the next year.
Next year.
So only 6 are there.
6 are there.
3 for autism and 3 for
defending.
deaf and dumb. But they say that 2 posts, 1%, the memorandum says again 1%.
My lord.
Now, if it is 1% of 6, it would be 0.00. It will not be even 1.
1.
So their king is that it will be on the total post.
How they have apportionment, that is their contention. My lord.
But here 2 posts were filled up by locomotor
They
category.
say that 1% of total advertised 244 posts.
2
Where
posts.
from they get this 244? Nothing in the notification, neither in the act.
So according to you, what would be the
Well,
method of apportionment?
Whatever is the second time backlog, that has to be interchanged and filled up by this year, my lord. They cannot carry forward in the subsequent year. That is what, my lord, here in page para 21 in the judgment.
And there is a statement somewhere, Mr. Dotto. You have made a statement somewhere that there are more meritorious candidates than the petitioners.
For that record was called for.
Oh, no, forget your records. You have made a statement somewhere.
In the PWD.
Page 51, para 12, last line.
Yes.
Therefore, some candidates in the locomotor who secured more
Okay,
marks.
what is the marks secured by the petitioners?
Petitioner Nilim Pathak, he secured 60.75.
Nilim.
Nilim Pathak. And Abu Ahmed Nurul Hassan, the petitioner in the other
Nilim Pathak secured?
60.75.
And other one?
Other one, Lordship, 41.75.
What is his name? Abu.
Lordship, Abu Ahmed Nurul Hussain Laskar.
He secured?
41.75.
So these are in locomotor.
Locomotor, Lordship.
Now in locomotor,
Lordship.
below,
Lordship. And two additional candidate, last selected candidate in the locomotor category, Lordship, Deepjyoti Talukdar, he secured 94.25. And
Deepjyoti Talukdar.
Deepjyoti Talukdar, Lordship.
He secured?
94.25.
And your Ailman Fidus?
Lordship, Ailman Fidus, Lordship, 96.50.
And Deep Paul?
Deep Paul, Lordship, 126.50.
Saurabh Biswas?
103.0. 103.
103.
103.
And Lakshya Deep Malakar?
102.75.
So these two candidates, Deepjyoti. Now between Deepjyoti and the petitioners, are there any locomotor candidates?
8 locomotor candidate.
Are there?
Lordship. That's under
Even if I bring in 3, it will be between the seniority merit position of the locomotor candidates.
Yes.
But at all, whether they have done this part or not.
Fine, they have not done it, we will do it.
If
We
they
will
have
do
not
it.
done it, the list is bad.
Oh, Mr. Chaudhary, how far do you think we will be academic? Let us also have some practical experience.
My lord.
If we do it, that 3 posts is apportioned, let's say, to locomotor. Forget these 2 candidates who were appointed. According to them, 1 person, forget that. Further we go down, then there are still 8 candidates above these 2 petitioners. You are not coming in.
That is a surprise to me because they have not stated anything in the affidavit. My lord, at least that we could have.
See, Mr. Dotto, you don't believe him?
No,
fine.
My lord, because sometimes we are.
That is fine. Mr. Dotto, if you don't believe Mr. Dotto, I can't help it. But
no.
At least
is something, my lord, sometimes
that faith.
My lord, faith, I also had. My lord, because we are answerable to, my lord, because these things will come in.
Mr. Dotto, show Mr. Chaudhary.
No, not only show, my lord, but some affidavit to that extent.
No.
The lordship will keep it parted and on this.
No parted business. Why show affidavit? No, keep it with you. You show him this, we'll take it up at 3:30. You go through.
Well, that, my lord, is the admitted fact because if my friend says, my lord.
No. Because I want you to look into it. Mr. Decca to look into it.
Well, when my friend has said.
No.
The other has said.
I don't believe Mr. Doctor.
My lord, at least this side of the bar.
I want a confirmation from Mr. Chaudhary.
But only thing is that, my lord, if
why do we do that exercise when it is an exercise in futility, Mr. Chaudhary?
If are giving a copy, my lord, of
that copy we will not permit. That copy we will not permit because it's a very kept close to the chest of Mr. Doctor.
I think my friend will.
The friend will give you the complete access to the file. You give him.
That's it.
3:30.
My lord, that aspect has not come to us because we have gone only.
Oh, Mr. Chaudhary will take 2 minutes to get that thing.
And
the smell is
only another issue is that, my lord, if in between that the person they selected and me, there are 8 persons. Whether, my lord, those 8 persons at all, my lord, because this is a mandatory provision which they have to interchange.
See, when I am deciding an issue, I can't ignore those 8 persons.
No, my lord, that your lordship cannot ignore. At least, my lord, they have not come before this court. I have come before this court for an
That argument was taken by Mr. Deka in another case, but Mr. Chaudhary, very rightly so, did not urge on that point. Mr. Deka knows it. Mr. Ken Chaudhary, Learned Senior Counsel, the whole writ petition was based on that, but Mr. Chaudhary, rightly so, did not argue on that.
Because, my lord,
Same thing. Second round of litigation, same issue. I think the judgment is ready. Kali Asini. Kali Asini. What was the name?
Midul Hazarika.
Midul Hazarika. Tomorrow, I think we will deliver.
only thing, my lord, that aspect, if your lordship gives me, because
You go through it. At 3:30, we will see. Yeah. Yes. Where is Mr. Chaudhary? Chaudhary? Yes, Mr. Monto.
Already decided.
He was already in trouble. Now you have come in and again put him into more trouble. He is not even coming to the
No,
court.
nothing to decide, my lord. Already it has been decided.
Oh, he was in trouble only. Now you coming in, he's now left the court.
No, I am not
Huh?
in that case.
Because of you only. Because of you only. He's not even coming now.
That was doing.
He'll come. Yes, Mr. Chaudhary, Monto, what do you have to say?
I have nothing to say.
This is covered case.
No, yes, my lord. That is already judgment has been delivered because who is.
Rightly, wrongly, this judgment has attained finality.
Yes, my lord. If there is a appeal, then different thing. I don't know whether appeal has been filed or not.
We'll dispose it of.
My lord.
You may not be here.
My lord.
You going only, he'll come.
I have another matter, item number 9.
9. 9. Mr. Monto,
My lord.
employees we understand. We are a scheme.
Seasonal.
Huh?
Seasonal. They are-
Seasonal, fixed pay, all these categories.
My lord.
How come VRS come?
No, there are two components. One is VRS and is closure benefit. There are two components. So I am entitled to get closure benefit.
What is that closure benefit?
Closure benefits, some lump sum has to be paid.
Oh, no, where do I get that
Like
law?
your earlier judgment,
Earlier judgment, we cannot go deep into because
no, my
it
lord,
was a general order. It was
No.
a general thing.
no, that not general, my lord. That is particularly that.
You
is-
show me the scheme.
Yes.
You show me the scheme
That scheme,
because
that
this
is not
was.
pilot. I am a simple casual employee. That is.
No,
I
I'm not
cannot-
asking the casual employee. I'm asking Mr. TJ Monto.
No, my lord, very
I'm not
difficult.
asking the casual employee.
No.
Mr. Monto, the problem here is it was a cooperative society, but it was considered as a public, a
Like a
state
sugar
public
mill.
sector, public sector enterprise, and it was closed down under that ADB scheme. Some benefits had to be given.
My lord,
And there is a office memorandum decision of the government to that effect.
my lord.
It was applied in State Fed, in many other organizations.
Correct.
Now, from that, you show me that even the casual employees, in addition to salaries, they are entitled to something.
My lord, I'm just pointing out one thing before. I just want to add something, my lord. At that point of time, some Sikh industries, that is sugar mill, polyester,
State Fed,
and these are the, my lord, then some PL has
Tube
been,
and Conductor, something limited.
some PL has been filed, and that PIL, my lord, Honorable Justice Ranjan Gogoi, and there's a division bench, my lord, give me the list of the employees, then we'll place before the government will take a decision. Accordingly, in respect of, my lord, sugar mill, 833 employees, my lord,
Were shortlisted.
one list was prepared. In our name was included in that list.
I got it.
It is not denied.
I got it.
Then, my lord, government has to take a decision. Yes, those who are getting permanent employee, they will get harassed. Those who are, because permanent.
Where is that decision? Just show me that decision.
I will come to that, my lord, because that is reflected in the judgment only.
Okay, fine.
My lord.
So other they will get closer benefit. I am agree because no option, my lord, because we are out of employment. So accordingly, my lord, and after the first round of litigation, my lord, I approached this disposal by this honorable court. They have given me only 2,200.
No, if they say that is the closure benefit.
No, there is a 1 month salary. They says.
Okay, 1 month salary. Where do I get what is the closure?
No,
benefit?
yeah, exactly that calculation made by the management and union, my lord, that was placed before the government, and that is in the hand of the official liquidator, my lord. That is why he was asked. Yes, if they shows that, my lord, yeah, this is the breakup, so I will be satisfied. But that's why this honorable court asked them to give the breakup.
Yes, Mr. Bodler.
So closer benefit, my lord, by 22,200. Cannot be.
It is not that. I only want to know what is closure benefit because that is not reflected in the judgment.
Judgment, my lord. Closure benefit, my lord, amount was not fixed.
Lordship, below, in respect of the casual workers, your lordship.
So I am not claiming VRS, my lord. VRS only, my lord.
Mr. Bodler, again, this is confusing.
Lordship, because
Permanent employee amount equal to 1.5 months salary at a time of VRS for every completed years of service, or at the time of VRS, amount of salary payable to the employees for the remaining period of service, whichever is less. So permanent employee done with seasonal employees.
seasonal employees.
Amount equivalent to 22 days of salary for every completed crushing season or service. Or at the time of VRS, amount equivalent to 15 days salary payable to the employees for the remaining period of service, whichever is less. So where is the calculation?
Lordship, calculation is not there, but there's a
was
list, your
put up
lordship.
for.
Huh?
There's a list of the selected employees, your lordship.
No. With regard to Mr. Mohanto's clients, where is the calculation?
Calculation has not been provided to me, your lordship.
That is what is we want.
That's why quote my last order, my lord, that was asked to produce that calculation, my lord. Because these are all the seasonal, they are working for more than 14 years, my 13, 14 years, my lord. Because another component is this, some of the candidates.
Because this court had not quantified the.
Yes, not quantified, correct.
And
absolutely correct.
further, the closure benefit, what it is
Exactly,
also has
I
not
want-
been gone into.
My
Not been gone into. So we'll have to understand what closure benefit is.
My lord. And in some of the employees, my lord, in respect of I came to know, my lord, that probably their provident fund money also have been deducted, my lord. But,
In your case.
but some of the employees, not all, my lord.
Naturally,
But that,
because
my lord,
that-
actually, my lord, that documents are now vanished, my lord. That will be very difficult to get it, my lord. That's why at least, my lord, the last occasion, my lord, they were asked to,
Mr. D. Bordele, learned counsel for the petition, for the respondent, shall on the next date of listing apprise this court as to the computation made in respect of each of the petitioners herein with regard to the closure benefits receivable by them on the closure of the, what was this institution?
Sugar mill, your lordship.
Assam
Assam
Cooperative Sugar
Cooperative
Mill,
Sugar
Belgaum.
Assam Cooperative Sugar Mill Limited, Golaghat. Golaghat. Also, Mr. Podler shall further apprise this court on the, as to what meaning is to be assigned, is to be given to the term closure benefit in respect of seasonal / fixed pay employees. Registry to list this matter again on
Money are still lying, some amount of money still lying in the bank, my lord.
No, if we can get this thing done, that money we will open it for you.
Because
But I'll have to understand what closure benefit is.
there's quantified, is not quantified.
It's not
Not
quantified. The meaning is not. I've read it twice, but that meaning is not given.
Benefit
You are
means-
entitled.
Benefit means some benefit. PRS, my lord, closure benefit means some government has to, my lord.
That is the problem because it might be 1 rupee, it might be 1 lakh rupee. How do we quantify that? There has to be some basis.
My lord.
And if that is
That
the
is
basis,
factual.
Mr. Bodler, show Mr. Mohanto that. If that is the basis, 2200 is the maximum you can get.
That is a salary only, my lord, for a 1 month salary. There is 1 month salary.
You look into it. You look into it.
My lord, my lord.
On 28th would be fine. 28th of, sorry, 28/1/2025, 26 for further hearing.
My lord, one thing. My lord, we have gone through it. My lord, only thing, my lord, without waiting up to 3:30, my lord, I have understood that I am not going to interfere. I cannot enter there, my lord, because 4 persons are ahead of me and 8 of them. Only thing, my lord, without dismissing if you all, because they have not come, only if your lordship remanded back to the APSC, giving them, they will.
Oh, they are very busy. New selection is coming.
My lord,
We don't
my
want
lord,
to give him
my lord,
further work.
my lord, they are agreeing to that. My lord. They are, he was saying that, my lord, if my lord, only thing that they can will consider, because for them their list is over. For them, they have not come. But if they have,
See, that will create a problem because the select list validity is only in respect of you.
this too.
I'm not going to allow them to make any appointment against that now. Enough, let it come in a fresh selection process.
Because, my lord,
Third day parties at length raised it to list this matter again on Thursday for further hearing. I'll pass the order on Thursday.
Thursday,
But
not
Mr.
on the
Chaudhary,
very first day.
not on the first day. I don't want to dismiss the matter on the first day. But I'm dismissing it.
My lord,
If you find out some atom bomb, come back.
my lord.
Yes. Heard Mr. M. Dr. Learned Counsel for the petitioner. Also heard Mr. R. Learned Counsel appearing for the Learned Additional Senior Government Advocate. Oh no, you are for the Learned Standing Counsel.
Standing counsel.
Public Works Department bracket roads. Assam appearing for the respondents number 1, 2, 3, 4.
My lord, respondent number 6, SP Chaudhary is appearing, my lord. He
Respondent
appeared in the
number?
morning. 6,
The private respondent.
private respondent.
Also heard Mr. SP Chaudhary, Learned Counsel for the appearing for the respondent number 6. The petitioners in the present proceedings have prayed for a direction upon the respondent authorities for considering their respective cases for promotion to the posts figuring in the grade 3 of the cadre, grade 3 cadre of the service in terms of the provisions of the Assam Ministerial District Establishment Service Rules 1967. Assam Ministerial District Establishment Service Rules 1967. Also, the petitioners herein were initially recruited against grade 4 vacant posts, against posts figuring in grade 4 in the establishment of the Executive Engineer, Public Works Department, Karimganj Rural Roads Division. POSOK. The petitioner, having served in such capacity for a long period of time and their cases not being considered for promotion to the next higher grades of the service, had approached this court by way of, you had approached earlier.
Yes, sir.
By way of instituting, had approached along with other similarly situated persons by way of instituting writ petitions being WPC number 5606/2010, WPC number 6103/2010 and 6232/2010. A coordinate bench of this court, wide order dated 3/11/2015, proceeded to dispose of the said writ petitions by directing the respondent authorities to work out the year-wise quota of year-wise vacancies in respect of the posts available in grade 3 category and including therein the post of lower division assistant and section assistant. Also, on such determination of year-wise vacancies available for promotion from grade 4 category, by applying the ratio of 90:10 as provided for in the provisions of Rule 6. Rule 6 of the Rule 6.
Yes, sir.
Rule 6 of the Assam Ministerial District Establishment Service Rules 1967 to fill up the said vacant posts. Also, while the said directions were issued by the coordinate bench of this, but that puts up before the issuance of the said directions by the coordinate bench of this court, comma, the provisions of the Assam Ministerial District Establishment Service Rules 1967, I suppose, no? 67 were amended by the amendment rules of 2015, which was notified on 15/10/2015. So, in terms of the amendment now brought into effect, for being eligible to be considered for an incumbent in the grade 4 cadre to be eligible for being considered for promotion to the post figuring to the promotional post identified in the grade 3 cadre of the service must have a graduate qualification. So, the petitioners in the present proceedings do not have a graduate qualification. So, in terms of the directions passed by this court wide by the coordinate bench of this court wide, they said order dated 3/11/2015, the Commissioner and Special Secretary Public Works Road Department proceeded wide a speaking order dated 6/12/2017 to deny the claim of the petitioners for being considered for promotion to the next higher grade to the post figuring in the grade 3 of the service on the ground that they did not possess the minimum requisite qualification for being extended with such consideration. So, being aggrieved, the petitioners have instituted the present writ petition. Mr. M. Dr. Learned Counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that this court having directed for working out the vacancies arising year-wise, comma, such determination now being required to be made for a period prior to 2015, comma, the law as the rules as it stood prior to 2015 would be required to be applied in the matter, and accordingly, the rules having mandated possession of a higher secondary qualification which the petitioners possess, comma, they are entitled to have their respective cases considered for promotion with retrospective effect against the vacancies so identified for the purpose for such promotion. Also, he submits that the petitioners, respondents herein, only by referring to the amended provisions of the Assam Ministerial District Establishment Service Rules 1967, have denied to the petitioners a due consideration of their respective cases for promotion to the rank of the proposed figuring in the grade 3 cadre of the service. He submits that the non-consideration of the cases of the petitioners for promotion to the grade 3 cadre has resulted in violation of the fundamental rights in this connection. Also, in the above premises, Mr. Dr. submits that the petitioners, the respondents be directed to comply, to implement the directions passed by the coordinate bench of this court wide the order dated 3/11/2015 and consider the cases of the petitioner against the identified vacancies so arising in the matter prior to 2015. Anything more? Mr. Doctor says there is nothing more to submit. Per contra, Mr. Ardhor, Learned Counsel for the respondent, submits that the cases of the petitioners not being considered prior to 2015, comma, their consideration now would be required to be extended by applying the amended provisions of the rules of 1967. He submits that the amended provisions of the rules coming into effect with effect from 15/10/2015, having mandated that for being extended with such consideration, an incumbent in the cadre of grade 4 must have a graduate qualification, comma, the petitioners admittedly not having such qualification, they would not be entitled to be extended with such consideration. He submits that petitioners who were involved in the earlier round of litigation, along with the petitioners herein, the writ petitions which were disposed of by order dated 3/11/2015 comma, who had the graduate qualifications were considered for promotion to the grade 3 posts as available, and they were subsequently promoted. However, similar consideration in respect of the petitioners on account of the fact that they do not possess the requisite qualification would not be mandated to be extended with. Also, I've heard the learned counsel for the parties and peruse the materials available on record. Also, the petitioners admittedly are working as grade 4 employees in the regular cadre in the establishment of the respondent number 5. Also, in terms of the provisions of Rule 6, bracketed B of the said rules of 1967, comma, an incumbent in the grade 4 cadre would be entitled to be considered for promotion to the post figuring in the grade 3 service in the event he possessed the qualification of HSLC and had completed 7 years of continuous service in the district establishment. The quota reserved for promotion was 10% of the vacancies arising in a particular year. Also, the cases of the petitioners not being considered for promotion to the rank of to the grade 3 cadre or to the post figuring in the grade 3 cadre identified for promotion from grade 4 cadre, comma, had approached this court earlier by way of instituting WPC number 5606 Uport J. Disilu. So this court wide order date, a coordinate bench of this court wide order dated 3/11/2015 proceeded to dispose of the said writ petitions by issuing the following direction, page 24, A2, A. So, before passing of the said order dated 3/11/2015, the rules of 1967 came to be amended by the provisions of the Assam Ministerial District Establishment Service bracket amended rules 2015, which were notified on 15/10/2015. In terms of the provisions of Rule 7 as amended, comma, for promotion to the cadre of grade 4, an incumbent in the grade 4 cadre is now required to possess a degree qualification. Admittedly, the petitioners in the present proceedings do not possess such qualification. Also, the above being the position, the matter on being examined by the commissioner and the commissioner and special secretary Public Works Department Dispur proceeded to reject the claim of the petitioners herein by issuing a speaking order dated 6/12/2017. Also, the claim of the petitioners was rejected only on the count that they did not possess the graduate qualification which was mandated in terms of the amended provisions of the rules of 1967. Also, the learned counsel for the petitioner have submitted that the learned counsel for the petitioner had submitted that this court, while the order dated 3/11/2015, having required the respondent authorities to work out the year-wise vacancies by applying the 90:10:10 ratio as provided for in the rules of 1967, and thereafter work out the promotional avenues available for incumbents in the grade 4 cadre and thereto effect promotions accordingly, comma, the cases of the petitioners herein must be considered by applying the rule that was so applicable on the date the vacancies so identified had come into effect. That much only. Also,
There
right of my lord to be considered for promotion was violated because.
In as much as a fund, it is a settled position of law that a right to be considered for promotion is a fundamental right. The said submission of the petition, Learned Counsel for the petitioner is being considered only to be rejected in as much as the Honorable Supreme Court in the case of State of Uttar Pradesh and others versus Rachana Hills and others, by considering its decision in the case of Rachana and Hills and others reported in 2023 SCC Online SC 506. By considering its decision in the case of State of Himachal Pradesh versus Rajkumar and others reported in 2023 3 SCC 773 had held as follows. Para 32. 33. So, applying the said decision to the facts of the present case, it is clear that even if the vacancies are now identified to be are found to be existing prior to 2015, the consideration that would now be required to be extended to the petitioners being a consideration in terms of the amended provisions of the rules of 1967, that is the rule position existing after 2015, it being now settled by the decision of the Honorable Supreme Court that such consideration can only be extended by applying the provisions of the unamended by the amended rules, the petitioners herein are found to be not eligible for being extended with such consideration. Also, the petitioners not having the requisite eligibility criteria for being considered for promotion to the post figuring in the grade 3 cadre, no right of the petitioners can be said to have been violated. Full stop. In view of the above conclusions, this court finds that the speaking order dated 6/12/2017 passed by the Commissioner and Secretaries, Public Works Road Department, Dispur, is not erroneous, and accordingly, the same would not mandate any interference. In view of the above discussions, the present writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, there would be no order as such.
There is an interim, I think, Madam.
Interim order passed earlier stands vacated. Sorry, Mr. Stand it. Yes. Yes, Mr. Chong.
My lord, Lord, kindly see page 48 of my petition, my lord. 7686. 48.
Yes.
Serial number 1. Kiran Lari, date of joining.
But date of joining is inconsequential here because 5/1/2005/9/2011 requires it to be on the basis of the merit.
Yes, my lord.
And
But-
this court had also said that.
Yes, it is there, my lord. But it was this order was passed on 8/11/2017, my lord.
What can it be?
Subsequently, my lord.
What can it be? The order of this court cannot be overridden by a ministerial order, can it be? You have not gone on appeal against that order.
Yes, my lord.
That's the end of
The order was passed, my lord. The order was passed on, my lord, 8/8/17. But
Mr.
this order-
Chauhan, show me that order is based on some material, some decision. Because the decision is 5/9/2011.
Yes, my lord.
And this court said do it in terms of 5/9/2011. What more is required?
But the approval of my lord select list was done on 28/2/2011, my lord.
Fine.
So, my lord, the 1/2, kindly see, my lord, date of joining 1/2/2011, my lord. Approval was on 28/2/2011, my lord.
You are Kiran Kaklari. When was the approval?
My lord, 28/2. From their petition, it will be clear, my lord.
28 to
2011, my lord. So, my lord, the date of joining will be subsequent, my lord. Thereafter, my lord. 1/2/2011.
your joining is 1. You are Baburam.
No, my lord, my
Oh, that will not create anything now. We'll only go by the direction passed by this court.
Yes.
By order dated earlier writ petition, wherein this court had directed to recast the seniority in terms of 5/9/2011.
yes, my lord.
We'll only go by that.
Thereafter, subsequent order passed, my lord.
Where?
Yes, this order has been passed, my lord, subsequently. 8/11/2017, my lord. 48, page 48. So, my
But
lord,
this was stayed by this court.
no, my lord. It was not considered in the subsequent, my lord. After the order, my lord. So, my lord, date of joining 1/2/2011.
This is what you have challenged in the present writ petition.
Yes.
We will say this is also bad.
Yes.
They will fix it up in terms of the merit position only.
Yes. And another thing, my lord, kindly see page 79 of their petition 5688, my lord. May I read, my lord?
79
of their petition. 5688.
79, it's not here. What is that document you want to show?
My lord, the order dated 7 March 2019, which is challenge under challenge.
7 March 2019.
Yes, 19. My lord. In pursuance of the order dated so and so of Honorable Guwahati High Court against order WPC number so and so respectively, along with the original Honorable Guwahati High Court's order dated 8/8/17 of WPC number so and so, taking in accord of
Because this came because in your case there was a stay order.
Yes, my lord.
Subsequently, the BTC authorities passed this order.
Yes, my lord. But
that is also without any basis.
Yes, my lord. But my lord.
We'll interfere with this. We'll interfere with that. We will say 5/9/2011. What comes, what goes, goes. Right?
Yes, my lord.
And now you have been promoted as senior assistant.
Yes.
They'll also be promoted if they are found to be senior to you. They'll also be promoted from that same date.
But that was considered.
That much.
By this order, that was looked into, my lord.
Where?
Yes, my lord. Kindly see. Fourth line, my lord. Taking in accord of the notification dated so and so, and letter issued by the principal secretary.
But while they have taken
5/9,
5/9, they have not applied it in terms of this is not the merit position.
But it is my lord. Considered.
That is why they are before this court. Otherwise, why should they be here?
I want to clear some there because Lordship may come to page 42, 41. This is a letter with inviting reference to submit here the district-wise gradation list of fixed pay employees. This document here annexed the date of joining of the parties.
I know that.
Here the
merit position was not taken into account.
Not taken into account, and the date of joining of the petitioner, this Kiran Kaklari, it was 1/3. It is from the very beginning, it is 1/3, and after passing of the High Court order,
it became 2.
It became 1/2.
But we are not concerned with it.
But that is not an issue, but the thing is that they have
Mr. R. Sharma, Learned Counsel for the petitioner, also heard Mr. R.S. Chauhan, Learned Counsel, heard Mr. R. Sharma and Mr. R.S. Chauhan, Learned Counsels for the petitioner in the above noted writ petitions. Also heard Mr. B.C. Musahari, Learned Standing Counsel, BTC, for the state respondents. So, hearing heard the parties at length. Hearing remains inconclusive. Registry to list this matter on Thursday. Thursday for the postpone. Thursday will pass.
Yes.
We are interfering.
Yes.
5/11, 5/9. Yes.
Wait, please. Lordship, we have I have obtained some instruction. Lordship. So, excellent, the amount has been paid to them.
300.
Yes, yes, yes. 3,500, get to number of days 300. Total amount 7,08,500.
Mr. CKS Burwa, Learned Counsel for the Learned Government Advocate appearing for the respondents. On instruction submit that the petitioner has been released her leave encashment benefits for the full 300 days. God, you are,
I'm not aware
okay,
about
okay. Your name?
D. Hajarika.
Ms. D. Hajarika, Learned Counsel for the petitioner, prays that she be given a day's time to verify the said aspect of the matter. Registry to list this matter again on 19/1/2026 for further hearing. You get your instruction, give her a copy.
For respondent number 2.
Mr. Boro, A. Boro,
R. Boro.
R. Boro, and Mr. A. Fukan, Learned Counsels, are present for their respective respondents.
Possible.
Madam, you get your instruction. And if we find that he got it in 2019, it will be difficult. He has not informed you. Even?
Please, Lordship. Lordship, in this matter, we have to take instruction, Lordship.
What instruction?
Whether he is still serving or not.
Why instruction is required? You see the affidavit. 44 years in 2017. 8 years, no, he's still serving. Only thing Upen Das will hold the field. You can't be regularized. Upen Das, whatever benefits are due, you will get it. What more can we do here? Yes, Mr. Nanda. Beyond Upen Das, I cannot go. My hands are tied. If you have something, go before the division bench after that. You have the decision of Upen Das with you.
No, Lordship, not with me.
But Miss U. Nanda, Learned Counsel for the petitioner. Budbara did not dispose. Registry hearing remains inconclusive. Registry to list this matter again on Budbar 7/1/2026 for further hearing. I'll pass Upen Das and whatever benefits are there from that date it was applied in respect of others, that will be applied in your case also.
Bless, bless, bless.
We asked Mr. Monto to leave because I thought because of Monto you are not coming in.
No, my lord. It's under.
Anything more? Dismissed. Book did dismissed. As naam kita likhi lo. Who is appearing for the district Dibrugarh Development Authority?
If someone has filed the affidavit,
Yes.
Lordship, for respondent number
No,
1.
someone is filed, but where is that someone?
Name is also shown, Lordship, in the cause list.
Get hold
Name
of
of
him.
the advocate.
Otherwise, going with Miss Bachaji, she can do nothing here. I'll have to get that counsel.
Yes, my lord. Also, on the last order, it was observed that the affidavit by respondent number 4 and 5.
What affidavit they will file? They can't file it. They need not, because this is a thing which is to be done by the development authority.
Yes, Lordship.
But they're taking a plea that the paucity of money and
Because that you get hold of him, we'll get out the money. You bring him here. Then get that man here. Passing an order in air will not do, will not help you. Get that man here, whoever that counsel is.
And they have.
Shall we keep
limited,
it for some
Lordship.
time?
I'm not acquainted with, but I can.
Item given it to
37, Lordship. Name is shown, Lordship.
Miss Evie Hussain.
Yes, Lordship.
Find out. The phone
Right.
number may be there. Right, Yasun? Or we'll ask the chairman to be here then, if nobody is appearing. Heard, Mr. Your name?
All Ascot.
Sir.
All Ascot.
Law Scott Learned Counsel for the petitioner also heard Ms. M. Bachchaji, Learned Additional Senior Government Advocate. It is seen that the respondent number 1 is represented by a counsel of this court. However, none has appeared on behalf of the respondent number 1. Also, Ms. Bachchaji, M. Bachchaji, Learned Counsel for the Learned State Council is requested to inform the chairman, District Dibrugarh Development Authority about the next date of listing of the matter so as to ensure representation of the said authority before this court. The said communication be issued through the Deputy Jurisdictional District Commissioner, Dibrugarh. Also, registry to list this matter again on 2/2/2025.
2 February.
Because I'll have to have that
Yes,
authority. If Ms. Bachchaji, Madam Bachchaji says that she is paying, I have nothing to say. There is
Lordship, actually, they already have admitted, Lordship, they
Yeah,
have
they have
paid.
admitted.
Yes.
They have admitted.
No, they have admitted that this is
They
my
pay-
headache. I'll have to fulfill
Yes,
it.
they are headache, Lordship.
And he is being very fair to that.
Yes, Lordship.
Yes. Nadia.
53.
Obliged.
Yes, Mr. Chaudhary.
My lord, in this case only my limited result.
You are 1916.
Yes, ma'am.
1961.
Page-
Show me,
Page 32.
show me after 1961 people were appointed.
I'm not getting any information
Then
regarding.
can't help it. 1961 is too far away.
Whether this list is still existent.
Can't help it. That is for you to tell
My
me.
lord, I'm not getting any information from the department. It's
You
only that-
withdraw it, file it with better particulars. We'll give you liberty. Or we'll dismiss it.
No, my lord, let it be pending. Let me take the instruction, my lord.
4 o'clock.
My lord,
This brief again.
my lord, my petition-
What you
to my
have
information-
filed a writ petition, nothing is there. Only thing is there that I am at serial number 1961. Now, if you are at 1961, whether anybody from 1962 has been
I'm
appointed.
physically disabled.
I got it. But the others are also physically disabled. It's not that you are the only disabled person in the
My lord, let me submit. My lord. Only one instruction from them, whether this is in existent or not, my lord. that
You satisfy me with material, then I'll ask them. Otherwise, I'm not going to ask them. Writ petitions must be complete in its all respect.
in 2 days.
That allegation should be.
Only 2 days. You may be given.
You have not even alleged that persons below you have been appointed.
2 days may be given, my lord. I'll take the instruction, whether anything happened or not.
Heard Mr. A.Y. Chaudhary, Learned Counsel for the petitioner at some length. However, Mr. A.Y. Chaudhary, Learned Counsel submits that he be granted time till Thursday to apprise this court with regard to the fact as to whether persons below the merit position of the petitioner has been appointed against the posts in question. So, prayer is not objected to by Ms. M. Bachchaji, Learned Additional Senior Government Advocate appearing for the state respondents. Registry to list this matter again on Thursday. 8th. Na besi asini. Dia kunina na idea. 21,
Lordship.
2026. Upward at the line, Ms. M. Bachchaji bole likhicho na? Shall also receive instructions as to the manner in which the select list in question was implemented.
Lordship. Deeply obliged.
Obliged.
I'm giving it for you.
Obliged.
Lordship, 30th record receipt. I just wanted days time, Lordship, to go through this.
Heard Mr. S. Learned Counsel for the petitioner. Also heard Ms. M. Bachchaji, Learned Additional Senior Government Advocate. Ms. Bachchaji submits that the records of the disciplinary proceeding instituted against the petitioner has been received.
Lordship.
However, she prays that she be granted a week's time to peruse the same and address this court. The pleadings in the matter is complete. Accordingly, admit the writ petition for hearing. No formal, as the respondents are represented, no formal notice is to be issued. Registry to list this matter for hearing on 3/2/2026. Mr. Count, 3/2/2026. Fine. What is your plea? Any procedural error?
Yes,
What is it?
there were independent witnesses were not called for.
Forget that. Whoever called for is more than enough for you.
The demand, recovery and acceptance, it has not been proved.
Only thing, is there evidence that the powder, penicillin powder was found in your hand?
The amount was not received.
The amount was in the dustbin.
Yes.
But how, there was powder, it was powder.
Powder was there, but
That red color was there.
Yes.
Enough, finished.
I will show.
Disciplinary proceed. And what happened to the criminal case?
That's pending.
Pending. You try your luck then. We can hear it now only.
Third.
I did not get that aspect of the matter in the file. Third. Okay. Preponderance of probability, witnesses after witnesses saying the lady went in, thereafter the police came, money found in the dustbin kept near you. What more is required in a department proceeding? Yes, Mr. Chaudhary, Vishnupuriam, this is item?
39.
Areas of pay.
My lord, in this matter, my lord, the petitioners are serving as ASIS CRPF, my lord. My lord, they are getting lesser salary than similarly situated persons. My lord,
This is pay parity only.
my lord, actually the grassroots of this issue is in the year 1997, my lord, because since Fifth Pay Commission has recommended for giving salary benefits to the Central Police Armed Forces, Central Police
They have
Forces.
filed an affidavit also.
Filed, my lord.
Explaining that you have filed a reply also. Okay, pleadings complete, we'll hear it.
Yes, my lord, Chief.
Heard Mr. M. Saikia, learned counsel for the petitioner, also heard Mr. R.K.D. Chaudhary, learned Deputy SGI, appearing for the state respondents. It is stated that the pleadings in the matter is complete. Accordingly, admit the writ petition for hearing.
My lord,
No, as the respondents are represented, no formal notice is to be issued. However, no formal notice is to be issued. Registry to list this matter for hearing on 5/2/2026.
my lord, actually it's a covered case, my lord. They,
We'll see. We'll see.
oblige, my lord, Chief.
You agree that it's a covered case?
My lord,
I don't
covered case.
agree.
You don't agree. So dispute it.
No, they covered case, my lord. After 70, you will reply, my lord.
This is item
40 mile. My lord, he was appointed in the year 2009, my lord.
Mr.
My lord.
He's your employee.
My lord.
Huh?
My lord.
You have released him. Where you have released him to where?
My lord, it is not our case is it is a termination simpliciter, my lord.
Where do I get it? This poor court will have to understand that this is a termination.
So, my lord, it is not.
Where is it?
My
Where is it?
My lord,
He's not a contractual employee. He's a regular employee.
My lord.
Huh? He's a regular employee. Where is this concept of termination simpliciter in case of a regular employee?
Not a regular employee, my lord.
Where do I get it?
If your lordship look into the, my lord, I'm not bringing all these documents today, my lord, and regarding the, my lord, provisions of the particular provisions, my lord. If your lordship look
Okay, in
into
the affidavit, have you said that? That he is a temporary employee?
my lord, in a repetition himself, the petitioner admitted, my lord.
Where?
Annexure 1, his appointment order, my lord. Annexure to page 15.
Oh, this I missed out.
My lord.
Yes.
My lord, there, my lord, this is their style.
During-
Oh,
during-
style.
There, my lord,
Style is different.
they have put that, my lord. Why,
Style
my
is
lord, I have
different.
different. Lordship,
3 months appointee
no,
release,
my lord,
what
I
is
have
there?
continued, my lord.
Fine, you continued, you
And
continue.
Lordship, look into page 5, my lord.
No, it
annex-
was taken by your statements.
And if
Even
you lordship look into the
temporary
page 5,
appointee
annexure
can
2, my lord. He himself admitted that he is not working since July 2021 and he is suffering from schizophrenia.
Page.
Page 5, annexure 2, page,
That we are sympathetic to him.
my lord.
Schizophrenia.
Schizophrenia. Being a
Medical
pharmacist,
report
my
is
lord.
also there.
My lord.
So he is not there. Wait.
So, my lord, he was.
Lordship, kindly my appointment for the so-called 3 months, my lord, page 15, my lord.
Where is your regularization?
My lord, thereafter, my lord, I was transferred to another post. my
Oh,
lord.
fine. That we have seen much. That side, this side, we have seen much.
Yes,
Transfer after appointment.
Yes,
Show
my
me your regularization.
No, it is not formally regularized, my lord. but they are-
Formally regularized, what is non-formal regularization, formal regularization?
My lord, here, my lord, there,
Now, the words you use will have to have some meaning.
yes, my lord.
Formal regularization and non-formal regularization, what is the difference?
My lord, in this regard, I have also annexed one judgment.
Judgment will come.
Supreme Court, my lord.
Will come.
My lord.
Show me the judgment.
There also, my lord, they took plea, my lord, page 56 in my affidavit in reply, my lord, that his appointment was temporary, my lord.
There is a difference, mister. In the case before the Supreme Court, he was a probationer.
Probation, my lord.
Probation is different. This is different.
My lord, my lord.
This is an appointment with you sitting in an AC room.
My lord, my lord, humble.
You have not sat in an AC room, have you?
From my little, my lord.
Mr. Mia, have you sat in an AC room before being issued with this appointment order?
Even, my lord, I am.
No, have you sat in an AC room?
No, my lord.
Then
I was working, my lord.
what is meant by AC room? Whether interview was taken? No.
Yes, my lord. It is done, my lord. Every lordship kindly with my approval, my lord. There is nothing so limited appointment. Lordship.
Where approval?
Page 14, my lord. This is their style, my lord.
14.
Page 14, my lord. And it is type copy, my lord, page 13, my lord. It is regular selection and appointment, my lord. I have seen, my lord.
No, show me where the advertisement was.
My lord, then I will annex.
No. Tell me now. You have annexed it. You have to get it.
Here, my lord, it was approved, my lord, for my appointment. There is nothing, my lord, 3 months conception. Lord, you kindly with page 13, my lord.
Have you challenged this appointment order?
No, Lord, I am satisfied. Lord. I continued since there were 10 years, my lord. 10 years, my lord, they continue. 10, 12
You are
years.
wrong. You are before the wrong court. Can't help it.
Because, my lord, law is that, my lord, even they cannot, my lord, terminate, my lord, temporary employee in this manner, my lord. Because, my lord, the department, and my lord, they issued also show cause notice to me, my lord.
That show cause was not.
Yes, my lord, issued, my lord. It was
The
not.
latest decision that show cause was not proceeded with.
Yes, my lord.
And they have relieved you in terms of the order of appointment.
Lord, kindly have a look. Their show cause once issued, my lord, page 48, my lord. They themselves issued the show cause notice to the petitioner, but it was not reached, my lord. It was not culminated, my lord. Page 48, my lord.
Fine.
He is a regular employee, my lord. It is their, my lord, for their reason, my lord. They, my lord, it was 3 months, my lord. If it is 3 months, is there, my lord. Why it was not terminated then, my lord, after 3 months, my lord?
Okay, why when it is written as 3 months, why did you not come if it is a regular appointment? Why have you not come?
My lord. Thereafter, he was transferred, my lord, and he was getting regular scale, my lord, and he was working regularly, my lord. No problem that, my lord.
Okay. Heard Mr. A.M. Barbuya, Learned Counsel for the petition. Also heard Mr. J. Chukia, Learned Standing Counsel, KAAC. Parties have been heard at length. However, hearing remains inconclusive. Registry to list this matter on 20 Budbar, Mongolbar, Parine? 27/1/2026 for further hearing. I'll dismiss it on that day.
Because, my lord, even, my lord, in the temporary law is that, my lord, I have some judgment, I have annexed, my lord. Even temporary employees,
That
they
will
cannot.
not help. If there is something more, show me on that day.
My lord, benefit goes, my lord, in my favor. Because, my lord, suppose, my lord, I am temporary, my lord. Why, my lord, thereafter, my lord, I am continued 12 years, my lord, in service, my lord.
Petitioner himself stated that he is not working since
months.
July 2011.
Might is state, my lord.
In the
Suppose, my lord, I am unemployed person, my lord, qualified, my lord, I am pharmacist, my lord, 3 months. Why, my lord, they continue 12 years, my lord, thereafter? And these 3 months,
We will
please.
say that your appointment will only be for 3 months. The rest money will be recovered from you.
Their style,
You show me any decision that you are entitled to a protection. This is not an order, simpliciter. I'll change my view.
yes, but because,
You-
my
you
lord,
bring
because
this-
they are so cause notice.
You bring decisions.
Decision I have already annexed.
That will not help you.
No, another I have annexed, my lord.
That is by this code. That will also not help you. You check up. Yes.
Apply, my lord. Please, your lord.
How can we help you here?
If discrimination has been meted out.
No. This community is not covered by the central government notification for state of Assam. Advertisement is very clear.
Yes.
Only communities notified by central government for the state would be applicable.
Yes, I was appointed. I was
Forget
important.
it. Your appointment
And
is on a an interpretation that you
Yes.
belong to an OBC community.
But lordship, the discrimination that is meted out, they have not denied.
What is the discrimination?
Of the same year examination, 2018 year, the person from the same community, that is the Bishnupriya community, has been allowed to continue with the same
One thing,
certificate.
whether he got his appointment because of the OBC category status?
Yes,
One.
yes, that.
Did he take a age relaxation for that?
Lordship, by applying he is OBC, yeah, paragraph 11, 18, I have categorically
Yes,
said they
sure.
have not denied. And the Honorable High Court has also, in terms of discrimination, same in a squarely covered case, allowed lordship. Squarely covered, it's never community only. In my case, the community is lordship, the Bishnupriya community. Because of discrimination.
Where have you stated that?
Yes, lordship. Para 18.
Para?
Para 18.
1-8.
1-8, page 10. Not only in 2018, in subsequent years also, they have continued. 1-8.
And what is the stand against this?
No, they have not denied. There are 13 of their affidavit. Page 81. lordship.
Yes, madam.
Lordship, we have verified it from the state authorities, and state authorities had also
Forget that. If the people belonging to the same community with the same certificate is allowed to continue, why not the petition? And they have made categorical statements to them. Why this discrimination? It is not a community which is not recognized. least it is recognized by the state of Assam. Nevar community was the same thing. You permitted half to appear.
Newar.
Forget it. Forget never. I'm only on this particular community. If people representing this community by utilizing a similar certificate like given to the petitioner is allowed to continue. And in all probability, given the community, it can only be from the Barak Valley, that area.
Yes.
So if they have been allowed, why the petitioners are not?
Lordship, here is a list we have annexed, and as per.
Forget the list. I got everything. It is not a community defined under the central list. But you are allowing similarly situated persons to continue. Why? Why this discrimination?
No, at present,
It-
what the steps the authorities have taken against them, that instruction is.
That you get it?
Yes, Lordship,
Get it?
that I have to take
Uh,
instructions.
In course of argument of the present, in course of his submissions in the present proceedings, Mr. A.R. Tabilda, learned counsel for the petitioner, has submitted that persons belonging to the community or belonging to the same community as that of the petitioners herein, by availing the benefit of the OBC category, are being permitted to continue in their respective services. However, the petitioners were discriminated against and their appointment came to be cancelled. You are in for the both the writ petitions.
Lordship, both.
Also, Ms. B. Sharma and Ms. R. Devi, learned CGCs appearing in the matter, shall receive their instructions and apprise this court on the said contention of the petitioner hearing. Registry to list this matter again on (6 to 2025), 26 for further hearing.
Right.
Further hearing, Nalai. To 2025. You get that? Who is for 4 and 5?
I am appearing with it.
Yes, why the amount is not being paid?
I am submitting.
Amount not paid till now.
Yes, my lord, because audit report is pending, my lord, pertaining to his period.
What?
There are some lordship anomalies.
When did he retire?
On
31st January 24.
Any show cause issued to him?
Nothing.
Lordship, only we have submitted the audit report and we are waiting for the.
What is the audit report to got to do here?
Lordship, maybe please to.
Have you drawn up any proceedings against
No,
him?
no, my lord.
Then why are you can't handle it? You can't keep it pending.
First page, my lord, lordship.
Pension you are getting.
Pension I have got.
Sorry, I shall do the GPA. Giving this, my lord. Even my lord, petitioner did not cooperate with the college authority.
No, that is a different thing. How can you withhold all these things? Only on the basis of an audit report. It's not permissible.
And last week, my lordship, already we have submitted the other explanation to the authority, my lord.
Yes. What is your department doing here?
For the GIS and the living was
Yes,
by
my
the
lord.
department. Yes, regarding this, it will be directly forwarded by the police to the AG.
No, you can't act in this manner. The council, you can't act in this manner. You can withhold everything provided there is something. Only basing on a audit report without even a proceeding being instituted. Release it.
Lordship.
Anything relating to misappropriation of fund.
Lordship, only audit is going on, my lord.
Forget it.
My lord.
Any misappropriation
No,
of fund.
nothing is found till
Then
my lord.
when are you releasing it? Proposing it?
My lord, sometime may be given, my lord.
Your name?
B. Burman, my lord.
Mr. B. Burman, learned counsel, appearing for the respondent number 4 and 5. 4 and 5. That is, the authorities of the Nirmal Haloi College submits that the petitioners GPF, GIS, leave encashment benefits, etc. benefits have been kept on a hold in view of the fact that an audit is underway in the college with regard to the period when the petitioner was functioning as the principal of the college. Also, he fairly submits that there is nothing, that no allegation of misappropriation of money has come on record, has come to the forefront against the petitioner hearing. He also admits that no departmental proceeding have been instituted against the petitioner. Also, if the above is the position only on the ground of a pendency of an audit, the petitioner's retirement benefits cannot be kept on a hold. Mr. Halloy, Mr. Borman, Learned Counsel for the respond number 4 and 5 submits that the college authorities would take appropriate decision in the matter and he would apprise this court on the next date of listing. Registry.
I would like to throw light on this regarding the departmental inquiry, Lordship. The departmental inquiry that was held, whatever proceeding was given to me, I have reported there in immediate action. Means I was asked to report.
Oh, the departmental inquiry, some punishment was imposed on you.
Yes, it was given, but now it is
What was the punishment?
one
given?
increment stoppage for 3 months.
What did you do with that? You accepted that?
No, sir, it was given to us. Sorry, Lordship, it was given to, it was.
Sir, Lordship, honor, no problem. You just address.
Lordship, it was given to me. Then I have reviewed the same. A review has been accepted.
And they have withdrawn that.
No, it has not been, it is under process. The review takes about 3 months time, 90 days time, Your Lordship. So it is.
You don't want to press this writ petition now?
No.
Your grievance has been met.
Because I have been given a permanent posting, to which if you want, I can show you.
You don't want to press.
Yes.
Mr. Kunal Debroy.
Yes.
Learned Counsel for Learned Petitioner, petitioner in Kunal Debroy, petitioner in person, has appeared in the matter. So, the petitioner in person submits that the grievance raised by him in the present writ petition has been redressed. Accordingly, he prays that he would not like to press the writ petition any further. In view of the Mr. H. Buragohai, Learned Standing Counsel, SBI, does not object to the submissions made by the petitioner in person. In view of the above submissions of the learned petitioner in person, the present writ petition stands dismissed on withdrawal. I see, in view of the order passed today in WPC number 5629/2025, no further order is called for in the present interlocutory application and the same also stands closed.
Thank you, sir. Yes, Lordship. Thank you, Lordship.
Please feel free to address any court in any language, any manner you want to, but it should not be discourteous. That's all. Lordship, sir, honor does not give any additional light to or aura to this court. Okay? So don't be sorry for that, what you have said. Yes.
May I please, as your lordship?
Not my matter, my lord. Sorry, my lord.
Every matter is Bhuya's matter. There cannot be no problem for that for discourse.
Sorry, my lord.
48. None. 48. Yes.
My lord, in this case, my lord, the writ petition is right, my lord.
That we know from 2020, 30, 10,
21, 2020.
No. It was it, yes.
No, IA was filed, my lord. What happened, my lord, IA we had to withdraw. Because, my lord, only the wife was, my lord,
withdrawn on 28/4/2025. Now, how can I consider this writ petition when nobody is there to press this thing? You have not filed a subsequent.
No, subsequently, we didn't file, my lord.
Then that is abated.
No, what happened, my lord? Actually, the
Stands abated, Mr. How can we consider this writ petition? So, Chakraborty, you were given time. You have not come back. Show me a way out, I'll do it. Because today this writ petition
yes, my lord.
is without a person who can press that.
Right.
An advocate cannot. The original petitioner is no longer in this one. What can we do?
Lord, the Liberty will file fresh.
Abetted. Mr. Goswami, in this condition, what can we do? Because we don't want to non-suit him also. He filed an interlocutory application withdrawn in April with the thing that we'll file a fresh one. That fresh one for the last around 8-9 months have not been filed. Now this is rudderless, cannot be considered. Now what to do?
If Liberty has been obtained, then he have to file a separate petition.
Liberty?
If Liberty has been taken at the time of withdrawing the earlier writ petition,
No, Liberty has been taken, but he has not filed the subsequent writ petition.
they have to file a separate petition now.
They have not filed. They'll have to file a separate writ petition.
That's what.
No, IA has been withdrawn, but subsequent IA for substitution has not been filed. So this writ petition, can we consider this? No, we can't.
No.
We can permit him to withdraw with liberty to refile. Huh?
That is the procedure.
That can be done. But Mr. R. Chakraborty, Lanka Council for the petitioner. Mr. Chakraborty submits that as the petitioner in the present proceeding has passed on,
21/2024.
Passed on, on 21
2/01/2024.
2/01/2024 and although an interlocutory application being IAC number 1209/2025 was filed, the same on account of certain technical errors existing therein was withdrawn with liberty. Also, although the liberty was granted by this court to refile the substitution application, the family members of the legal heirs of the petitioner has not approached him.
In that Liberty, time was not, there was no time mentioned in the order.
Oh, can it go on?
No,
That's
that's
a perpetuity. Abetted petition has not approached him for filing a subsequent application for substituting themselves in place of the original petition. In view of the above position, he prays that he be permitted to withdraw the present writ petition with liberty to the heirs of the writ petitioner to file a fresh petition if the occasion so demands. Prayer accepted, writ petition stands dismissed with liberty as prayed for.
All right.
49 lawsuit we issued in compliance order.
My lord, the department has rejected, my lord. Regarding, my lord, one.
Page 16 is a direction lawsuit. Para 5.
Yes.
My lord, peruse the paragraph 3 of page 3 of my contempt petition for a moment, my lord.
Forget the complaint petition. What is the order? Order is
To
requiring them to consider,
To verify, my lord.
verify. They have verified, maybe wrongly, but where is the contempt now?
Well, that is true, my lord.
Heard Mr. S. Hazarika, Lanka Council for the petitioner. Also heard Mr. SMT Chisti, Lanka Council appearing for the respondents. Also, Mr. Chisti has placed on record an order dated 24/9/2025 passed by the Director of Secondary Education Assam, rejecting the claim of the petitioner hearing for being granted an advance increment for acquiring B.Ed degree in the year 2010 from IGNOU. Also, this court has perused the order dated 17/5/2023, violation of which is alleged in the present contempt petition. On a perusal of the directions so passed, this court finds that the directions passed by this court have been substantially complied with by the respondents by issuing the order dated 24/9/2025. Accordingly, accordingly, there being no violation of the directions passed by this court by the order dated 17/5/2023 in WPC number 6389/2022, the present contempt petition stands closed. However, liberty is reserved to the petitioner to present a challenge to the order dated 24/9/2025. If so advised. Copy of the order dated 24/9/2025 as produced by Mr. SMT Chisti is kept on record and marked as X.
Obliged.
Yes.
My lord, the service as regard to the respondent was 7 and 8 is not complete, my lord. Lauzima, the order of civil fine. 12/11/2025 order passed by Lauzima court. I have taken.
You want to
steps-
take Dasti?
Yes, my lord, twice I have taken the start.
Okay, fine. Ms. P. Borman, Learned Counsel for the respondent submits that as the service of notice upon the respondent number 7 and 8 have not been effected, could not be effected by way of registered post as well as also by way of usual court process, she be permitted to take steps for service of notice upon the respondent number 7 and 8 by way of Dasti mode. Also, prayer accepted. Petitioner is permitted to effect service of notice upon the respondent number 7 and 8 by way of Dasti mode routed through the registry of this court. Upon effecting such service of notice by way of Dasti mode, the petitioner shall file an affidavit to the said effect. Also, registry to list this matter again. Sari Hopta Pisante. 9/2/2025.
51 analogous matter, my lord, service is complete, my lord. So far, 20.
51 service complete. 51 not likha. Ito 50 likhi pade.
Both are tagged together.
Ito likha 4151 not likhi ba. Registry to list this matter again on 9/2/2025 along with other two.
May I please, your lordship?
Hmm.
Your lordship, service upon all the respondents has completed, lordship. As per the Lauzima order dated 6/11/25, lordship.
Seen the Lauzima court order dated 6/11/2025, which reveals that the service of notice upon the respondent number 7 and 8 have been completed. Also, in view of the above, registry to list this matter again for admissions on very much 10/2/2020.
I'm preparing for my lord.
Mr. R. Dhar, Mr. R.K. Talukdar, and Mr. A. Chalia, Learned Counsel, are present representing their respective respondents.
Mass of Lord.
53, we have issued a speaking order, lordship. Directly that was at page 21, para 12, lordship, may kindly peruse.
Just he is informed, my lord, and that my submission is that, my lord, a copy of the order may be served upon me so that I can.
I served that now.
No, not served.
Mr.
From the, oh, yes.
Mr.
You have not
Chisti-
served.
Oh, yes.
Mr. Chisti is trying to say something to this court. Let
Yes,
this court
yes,
understand.
Yes.
You know, I don't have that much of capacity here. I'll have to have that with that small capacity. I'll have to understand.
Oh.
Yes, Mr. Chaudhary.
Yes, that the direction is at page 21, para.
Accordingly, directing the so and so to verification of all records in respect of the petitioner. Produce document. Thereafter, verification is the found to have been legally appointed in terms of the employment notice dated so and so. Arrears salary with effect from so and so as well as current salary of the petitioner shall be paid to the petitioner within period of 3 months. Now, in your examination, what have you found?
It was found as not found to be a legally appointed lordships. Nor her name is appear in the illegal irregular category that was the screening committee was lordships held in terms of the honorable court's direction lordships. Nor her name was found in that illegal irregular category.
That means she is regular. If she is not there in any committee, she is regular.
Yes, my lord. And that, my lord, that honorable court was, while disposing of the petition, honorable court was pleased to record that, my lord. Lordship, kindly see paragraphs 8 of the judgment, my lord. Paragraphs 8, page 34. This is contrary to the order of the honorable.
Sagar.
Ipsagar.
Yes.
All those-
Lordship, kindly see paragraphs 8. Let my lord.
Okay. Mr. SMT District Learning Council for the petition, for the respondents submits that the directions passed by this court wide order dated 13/8/2024 in WPC number 5509/2024 has since been complied with by the respondents wide issuance of an order dated 3/1/2026. Mr. 3/1. Other day. Mr. J.M. Chaudhary, Learning Council for the petitioner submits that a copy of the said order has not been furnished to the petitioner or to him. So accordingly,
I have furnished.
I have not furnished.
Mr.
Yet not
Chaudhary,
furnished. He will furnish.
Mr. J.M. Mr.
This one, oh, yes.
SMT Chisti shall furnish a copy.
Yes, yes.
Mr. Chisti is furnishing copies day in and day out, so he may make a mistake. Why do you get agitated for that?
Oh, Lord, he's
No, no,
submitting. as
I thought I had submitted laws.
Only
No,
I'm
no.
submitting.
In many courts, you might have found he might have submitted 10 orders like this.
Sorry. On that, I am sorry, ma'am.
Please. Mr. SMT Chisti shall furnish a copy of the order dated 3/1/2026 to Mr. J.M. Chaudhary during the course of the day. Registry to list this matter again on Budhbar Media. On
In
Wednesday.
the meantime, I can file a reply, my lord.
On
Or
Wednesday.
reopening, my lord.
On Wednesday.
I'll have to
My
come
lord.
with affidavit.
No need.
No need.
Wednesday,
Yes.
no app reply. You see whether it has been complied with. If not, tell me. We'll
Yes.
see.
Yes,
Obliged to.
obliged.
We are having it on Wednesday.
Yes. Yes.
Yes, Miss Sinha.
Wait, this. My lord, this is a simple petition for application for impleading respondent number 6, respondent number 6. My lord, the agriculture officer, they are wanting to give the pensionary benefits to the respondent whom we want to make a.
2 wives.
Yes, 2 wives. So, my lord, the first wife is married much earlier.
Why was she not implemented in the
Yes.
main writ petition?
Main writ petition, she was not even later on when she went to find out why it is not paid to her. Then she came to know that the pensionary benefits are considered to be paid to this second one, whom we don't have any objection here to be a party now. Let her be a party, then only this can be decided.
This is your husband's name?
Husband is Pradeep Saikia. Yes, he died on 5/1/18. Before that, the conversion of the first wife to Muhammadan, that happened, and later this wife Gina Bora, the applicant, she did not know about the status. When she went to inquire about the pensionary benefits, she came to know that one Sumi Saikia, whom we don't have any opportunity, she's a party
This
now.
lady whom you want to now
Yes.
implead,
Yes,
Nazmina Begum.
yes. She is converted.
She was the original wife of your husband.
Yes, yes. She
Huh?
was converted to
She was the original wife of your husband.
original was Dina Bora, now the applicant. In between, the Sumi Saikia, who is converted to Muhammadan, she is the second wife. Anyway, she's the second wife.
Oh, she is the second wife. She is
Yes.
the wife.
The first wife.
And after the death of your husband, she has now remarried.
Yes.
But the
Not
authorities are now
remarried.
proceeding to release the pension in her name.
Yes, my lord. She was converted a long time before his death. So everything happened, but that is hushed up.
Okay. But
So
Miss the
we-
Sinha, learned
okay.
counsel for the petitioner. Any objection? You are appearing for whom?
For AG,
Huh?
Accountant General,
Okay. Also heard Mr. A. Burwa,
A. Burwa.
learned counsel appearing for the respondent number
3.
3. None appears for the other respondents. Also, the petitioner, by way of instituting the present writ petition, has sought to implead page 4, A to A, no?
6. Yeah.
A to A, as party respondent number 6 in the connected writ petition. It is projected that the proposed respondent has projected that she is the second wife of the husband of the petitioner, of the applicant. And there is a move on the part of the respondent authorities to release to the proposed respondent the pension and pensionary benefits due on account of the services rendered by the deceased husband of the petition of the applicant herein. Also, in view of the perused the contentions raised in the interlocutory application and also heard the learned counsel for the petitioner. On our examination of the matter, this court finds that the proposed respondent, Musammad Nazimina Begum Chaudhry, is a necessary and proper party to the issue arising in the connected writ petition, and accordingly, she is required to be impleaded as a party respondent in the proceedings of WPC number 3947/2019. In view of the above, the present interlocutory application is allowed by permitting the petition by the applicant to implead said Musammad
Nazmina Begum.
Musammad Nazmina Begum Chaudhry as a
Bracket
party
mistake,
respondent
yeah.
number 6 in the connected writ petition. So, disposed of her. Next. In view of the order passed today in IAC number 2909/2025, impleading A itia agote A to A disilude. Itia A1 to A1 deliver. Petitioner to file an amended cost title within 2 working days from today, incorporating the name of the newly impleaded respondent. Also, on filing of such amended application, petitioner to take steps for service of notice upon the newly impleaded respondent by way of speed post as well as by usual process steps within a week
Deeply applied, my lord.
after filing of the amended cost title. You are there for agriculture.
Petitioner
Mr.
expired. So substitution application is in file. If the legal is.
Any objection? Clear objection.
I can't.
Heard Mr. S.K. Goswami, learned counsel for the petitioner. Also heard, for the applicants, also heard Mr. R. Dot, learned additional senior government advocate appearing for the state respondents. The connected writ petition, being WPC number 2557/2025, was instituted by Bipul Tumung. Also, however, during the pendency of the said writ petition, Bipul Tumung passed away on 18/8/2025. Full stop. Accordingly, his legal heirs have instituted the present interlocutory application, praying for their substitution in place of the original petitioner Bipul Tumung. I perused the contentions raised in the interlocutory application as well as in the connected writ petition, and find that although the original petitioner has since passed away, comma, the cause of action remains. There exists what do you call that? Objectionable claim. There exists a cause of action. So there survives a cause of action. The cause of action survives, and accordingly, the same would be permissible to be taken forward by the legal heirs of the original applicant. Accordingly, the applicants are permitted to substitute themselves as petitioners in place of Vipul Tamang in the following manner. A2, ekdom yaar pa maribo de. On the death of Vipul Tamang, his legal heirs, page 3. With the above observations and directions, the present interlocutory application stands disposed of. WPC. In view of the order passed today in I(C) number 3603/2025, impleading the legal heirs of the original petitioner Vipul Murum in the following manner. A to A, yet on the death of so and so. The petitioner to file a amended cause title within 2 working days from today. Registry to thereafter list the matter for admission hearing on a date we fixed by it. Please.
Please, Your Lordship. Lordship, this is a BSF pension matter. The respondent number 5 has filed this IA stating that their name has to be deleted from the party respondent as they have no role to play.
Who is for the petitioner?
I'm for the petitioner, Lordship.
You're for the petition.
We have no objection.
You have no objection?
No, Lordship.
But Ms. B, sir, you are appearing.
I'm for 1 to 4. This is filed by AG Assam. AG Assam has no role in this case.
The present interlocutory application has been filed by the applicant who is the respondent number 5 in the connected writ petition. Also, being WPC number 4615/2025. The present interlocutory application has been filed praying for deletion of the name of the respondent number 5 in the connected writ petition on the ground that the issues involved, that the respondent number 5 is in no way connected with the issues arising in the said writ petition. The learned counsel for the petitioner does not object to the prayer made in the interlocutory application. So accordingly, the name of the respondent number 5, that is the Accountant General, it was a page 2, A to A. Assam Moidamgaon Beltola Guwahati -781029 is deleted from the array of respondents in WPC number 4615/2025. Also, with the above observations and directions, the interlocutory application stands disposed of. Writ petition. In view of the order passed today in IC number 3626/2025, deleting the name of the respondent number 5 from the array of respondents in the present writ petition, petitioner to file a amended cause title within 2 working days from today. Also, on filing of such amended cause title, registry to list this matter again for admission hearing February 11/2/2025. 2026. Interlocutory application. Yes, Mr. Bhuya.
My lord, in the main writ petition, my lord, we have challenged the promotions of the private respondents, my lord, in the post of senior accounts assistant from junior accounts assistant in the treasury establishment of Haflong. Lord, the main grounds of our challenge in
Okay,
the,
we'll consider that.
my lord, in the writ petition is that, my lord, that the roster point, 13-point roster point had been violated and which had been approved by the WPT and BC department. Now, my lord, subsequently, another exercise has now been decided to be carried out. And, my lord, a gradation list had been published during the pendency of the present writ petition before this honorable court, my lord. And in that gradation list, my lord may be pleased to find at page 23, my lord. Page 22 is the order, my lord.
Okay, Mr. Bhuya,
My
before
lord.
we come to that,
My
you were required to effect services of notice.
Yes,
upon
my lord, we
responding
have
7 and-
taken, my lord. No,
18,
today,
12.
today Lord, today we have deposited, my lord.
What?
The service, my lord, for the service. And, my lord, may I take the liberty, my lord, to effect the same by Dasti mode also, my lord.
A repetition only.
But, my lord, only apprehending, my lord, that
Seen the office note dated 8/12/2025, which reveals that. No. Office note dated 18/12/2025, which reveals that the petitioner has not taken fresh steps for service of notice upon the respondent number 7 and 8. Mr. A.R. Bhuya, Learned Counsel for the petitioner, submits that the steps have been taken today. That is the date today. So, in view of the above, registry to verify the said aspect and to issue notices upon the respondent number 7 and 8 as directed by this court vide the order dated 20/12/2024. Also, 20/12/2024. Registry to list this matter again on what time, dear?
Lord,
Into interlocutory application. Yes.
my lord, in the interlocutory, my lord, what has happened during the pendency of the main petition, my lord, they have initiated another exercise at page 22, my lord. A gradation list has been published for this next subsequent promotion, my lord. So, my lord, if these persons, my lord, these private respondents, my lord, is already in the cadre of, my lord, senior treasury accountant.
You are in the cadre of?
In the cadre of junior treasury accountant, my lord.
So if
Their promotion is disturbed, my lord, then we will be inducted in this cadre, my lord. That is
Okay.
this senior treasury.
Where are you placed? What is your name? Hinting Lutham.
My lord, our name is placed here, my lord, in the at page 2 and 3, my lord, 23. Serial number 2 and 3. 2 and 3, my lord.
Gautam Bora. No.
My lord, 1, 2, and 3 is the writ petitioner before my lord, my lord. And the private respondents are, my lord, 6 and 7 in the next upper column, my lord. That is the senior treasury accountant, my lord.
Rupasri Das and Vishwasit.
My lord, my lord.
They have already been promoted.
No, they are already been promoted by violating the rule as well as by violating the 13-point roster.
That is under challenge.
That is under challenge. That's why, my lord, my respectful submission before my lord is that, my lord, if their promotion is allowed to be go on, then this illegalities is going to be perpetuated.
No, they are promoted to which post now? They are
From, my lord, junior treasury to the senior treasury account.
Oh, that they are already promoted private
They are
respondents.
already promoted, my lord. That's my respectful submission, my lord, is that if they are being promoted illegally by violating
That is why the writ petition has been filed. We will consider that.
No, my lord, if they goes to the next higher, my lord.
Next hire. Next hire is what?
Next higher is, my lord, the chief treasury accountant, my lord.
Chief treasury accountant. How many posts are there?
At present, my lord, 2 posts.
2. How many people are there above them?
1, 2, 3. 5,
Oh, 5.
6, 7. No, my lord, there's some roster, maybe they posted roster and
2
reserve.
posts. Roster. Mr. Bhuya knows better.
My lord, it may come because they are not following.
Madam, you are appearing for?
I'm appealing for 5 and 6, my lord.
They are not
That
following.
is the persons
my lord,
whom you want to stall.
Yes, my lord.
No, no.
Okay.
No.
They are
5 and 6,
before they go.
5 and 6 is
They-
the official, my lord. Treasury officer, my lord.
No, Dimas.
Oh, Dima also.
Oh, Didi Bima.
Private respondents are yet to come.
Yet to come.
Yet to
Steps
come.
have not been taken.
Steps has not.
No, my lord, once we have taken, but
Heard
those.
Mr. A.R. Bhuya, Learned Counsel for the petition. Also heard Mr. You are for personal.
No, my lord, yes, I will pay
WP
personal also.
For Mr. A.R. Dhar, Mr. R. Dhar, learned counsel for the learned additional senior government advocate, and Ms. Chakraborty, learned. You are appearing for standing counsel?
5 and 6, my lord.
5 and
Yeah,
6.
yeah.
Learned standing counsel, Dima Hasaw,
It's-
autonomous counsel. Also, issue notice. Returnable 4 weeks. Also, as Mr. Thor accepts notice on behalf of Mr. of behalf of respondents number
Respond.
3,
3 and 4.
3, 4, 3 and 4. While Ms. Swan's learned counsel, learned standing counsel, Dima Hasaw accepts notice on behalf of respondents number
5 and 6.
5 and 6. Also, petitioner to take steps for service of notice on respondent number 1, 2,
My lord, 1 and
5.
2 is.
5. Oh, Mr. A. Cholia. I was directing to take it through him. Mr. A. Cholia accepts notice on behalf of Upod A. Cholia to likhi di pare. Standing counsel, finance department 1, 2, and 5.
5 I'm appearing, my lord.
5 will appear, Treasury, 1 and 2. Also, no formal notice is to be issued. However, requisite extra copies of the petition be furnished to the learned counsel for the respondents. Petitioner to take steps for service of notice upon respondent number 7 and 8 by way of registered post with AD, by way of speed post, as well as by usual process, steps within 2 working days from today. Agor eto interlocutory petition to ketia fix korish
13th.
13 registered to list this matter again on 13/2/2025 along with the connected petition. We'll see on the next.
Lord, may I pray that the status quo as regards the gradation?
They are already there. They are not going above you to the next higher grader so soon. It will take some time. Don't worry. We'll work it out. Any promotion, you have filed a writ petition, any promotion will be subject to outcome.
Yes.
Don't worry about it.